Honorable King as Friday presiding.
Good morning, Carol.
Please be seated and come to order.
All right. Good morning.
Good morning, Judge. How are you?
Good.
Morning.
I don't know, how am I guess, is the
I
question.
think we're good.
Okay.
Your Honor, the Commonwealth has elected to proceed on one count of aggravated within 3 years and one count of aggravated, same transaction. We have presented one instruction for each of those
Perfect.
counts. It is the model. We have added to that one instruction that had not been previously provided for child endangerment. We will not be
Right.
going forward
And I'm
on
going to take out the child abuse one,
abuse and
correct?
neglect, exactly.
Okay.
And then we have withdrawn, and I can tell you which letters,
Okay.
instructions
Alright.
that were related to
Sure.
first degree, second degree.
Let me, hold on a moment, just for the record, which counts of the 4 counts of aggravated murder are you going forward on?
One moment.
Either 1 and 3 or 2 and 4. I think those are the options.
Right.
But I just want to make sure for the record.
And I'm sure you're right, Judge, but we'll open it really quick and just
Okay,
make sure
sure,
that
absolutely.
our 1 and 3 and 2 and 4 are the same as yours. Sure.
So,
So 1 and 3?
1 and,
No,
1 and 4.
1 and 4.
1 and 4?
1 and 4.
Okay, absolutely, that's fine. Any objection to that then?
No, you aren't.
All right, so we're going forward on count 1 and 4 of the case number ending in 666. And then for 2 and 3, there's a motion to dismiss
dismiss.
those.
Oh, wait,
so you have
okay,
no
hold on, I'm
objection to-
getting
I'm sorry.
tapped.
No, ma'am.
Wait a minute, hold
Yeah,
on.
let-
There seems to be a change here.
Sorry, we're gonna
Okay.
read this one more time.
Same after transaction.
Yep,
1.
1.
for Ryan. 4. Same 3-year period, Christine, yes. 1 and 4. Dismiss
Oh, you're-
2 and 3.
Okay,
Yes,
final answer?
yes.
Okay, 1 and 4, so we're dismissing 2 and 3 with no objection.
No
Okay?
objection.
All right, so 1, 4, and 5 under the case number 666, and then we just have child endangerment on
Which
the
is,
one ending in 873.
that's
Okay,
count 1, Judge?
That is count 1.
Yes.
So count 2 is dismissed
Yes, ma'am.
on that, on 873. Okay, fabulous. So now I have the ones before that we had talked about. Do you just want to go through those?
Yes, ma'am.
Okay,
And I will pass up our new stack. They're clean. They have the
Okay,
letters typed
excellent.
in.
all right, so I had
That's
instruction A, which I assume is still the same, correct?
Yes, ma'am.
Okay, and then we'll withdraw instruction B since he did
Correct.
testify? Okay, withdrawn. And then you still have C,
Yes,
okay. D,
yes,
E,
yes,
F,
yes.
G,
If they stop sticking together, yes.
all right, and then H.
Judge, I have an I next.
Oh, I'm sorry, H is child abuse, so you're
Yep,
throwing that
so
one.
that would be withdrawn.
Okay, fabulous. All right, and then we have I,
Yes.
okay. Q,
So Judge Q would be withdrawn?
Q is withdrawn, I assume without objection.
Without objection.
Okay, Q is withdrawn. Okay, what do you have next? R?
I actually had an L.
Okay, you had L. I switched them around a little bit because.
That's okay, because they didn't make sense in that order. That's fine.
Well, not to me, but.
Nope, that's A-okay, I can track.
I could,
So
that's fine, I'll just.
if you're on R next, we would withdraw R.
Withdraw R, okay.
We would withdraw S.
I have M next.
Okay,
M
so
as in Mike.
M is in.
Okay. S as in Sam,
S as in Sam would be withdrawn.
okay. N as in Nancy,
Yes,
O,
yes,
P,
yes,
T as in Tango,
yes,
okay. And then I think, let me see, then I have some of his instructions. I think that's all I had for you. So which ones would you like to add to that?
So I have L, which was willful.
Willful, okay, you have L.
I do.
All right, do you have a copy?
I
Well,
do.
You got the clean copies,
Yep,
that's
I'm
fine.
gonna
Okay,
pass that
so
up to Your Honor.
we'll add L, okay, and what else?
And then I have U, which is the instruction for aggravated murder, 3-year period.
Okay,
And then I have V, which is the instruction, aggravated murder, same act or transaction.
okay.
And then I have X, which is the crime of child endangerment.
Child endangerment, okay. And your U and B have the waterfalls also?
They do not, Judge.
You're not doing
We are not
waterfalls.
doing a waterfall.
You are just standing on aggravated murder?
We are.
Okay, that is your option. Do you want waterfall instructions, Mr. Carroll?
No, Your Honor.
No.
I'm gonna stand on as well.
Okay, so we're standing on aggravated murder. You've just made life a lot simpler for me on your decisions, but that is your decision. Okay, so no waterfalls, we're standing on aggravated murder.
Yes, and I'm passing them up with the previously agreed upon new separate so that you can put them in as you
Okay.
would like them to appear.
All right.
I also understand we've agreed to defense 2, 4, 10, 12, 16, 20, and 36.
I think that's what I have.
No
Let me make
changes.
Sure. That's the only, those are the only ones I had already had, correct?
Correct.
Yes, Your Honor.
I have 2, oh, I do have L, okay, sorry. I do have 2, 4, 10, 12, and 16, and 20, and 36.
Yes, ma'am.
Okay, anything to add to those, or that's it?
No, Your Honor.
Oh, you guys get a gold star today.
Thank you.
Okay, that is fabulous. All right, so you want to hand me up the, you have the clean copies for your, oh, you already gave them.
Yep.
Okay, I got the clean copies. And do those include Mr. Carroll's, or Mr. Carroll, yours were already clean copied, correct?
The ones that I handed up before were clean copies.
Okay, so I can just insert his into
Yes, ma'am.
yours. Perfect.
And
I
at
can
this
do
point,
that.
we owe you a verdict form. Now that you have accepted those
Right,
instructions.
yes, I have those instructions.
We will provide you with a verdict form.
Okay, oh, that's fine. So if you want to provide a verdict form, I can have Shannon do one since it's just aggravated murder now. It's not too difficult.
If
I can do that.
that's just fine.
So we'll do 3 verdict forms, one for aggravated murder, one for firearm, and one for child endangerment.
Yes,
We're on
ma'am.
the same sheet, music? Okay, good. 3 verdict forms?
Ms. Frisler is asking, do you think we need 2 aggravated murder forms?
Oh, yes, I'm
Given that there are
sorry.
2
I
separate.
apologize, you're right, because you did go ahead and do both, same occurrence and 3
And
years.
3
Yes,
years.
so we need 4 verdict forms. Aggravated murder in the same act and transaction, aggravated murder in 3 years, firearm, use of firearm, and child endangerment. Okay, we'll get those together.
Perfect, thank you.
And by the end of closings, we'll be able, you can review them before they go back to the jury.
Great, thank you.
Okay?
Your Honor,
Yes,
is
sir.
there an order that you're going to be calling out the jury instructions?
There is. Let me just put it back into the
Okay.
order, and I will let you know. And I will actually get copies to you as well,
Okay,
in the order that I'm going to give them, and I'll get one for the court reporter too,
Oh,
Carol.
great, thank you.
So I'll do that. We'll have time to do that, okay?
okay.
So that takes care of jury instructions. Do I have Ms. Smith here yet? Ms. Smith, are you here? Are you ready for your motion? Yes. Let's go. Is that okay?
Yes,
I'd
absolutely.
rather do that than I can go back and put those instructions all
Yes,
in
ma'am.
order. Ms. Smith, you can just come to the center podium, that's fine. Thank you. Apologize, these were all withdrawn.
Just want to make sure I have the right Miss Smith. This is for the access motion?
Yeah, yes.
Okay, great.
Well, you're Ms. Smith, so.
Well, no, I know.
You
I
answered.
There could be multiple Miss Smiths, so I wanted to make
Well,
sure.
the odds were pretty good that that I had the right person. I know it was set for 9:30, but since we were so organized today, if it's okay with you, I'd like to go ahead and do it now.
Absolutely.
All right, I've read your motion.
Thank you.
So you don't need to regurgitate it, but anything you want to add to the record, you're welcome to.
Oh, thank you. No, I mean, I appreciate you reading it. And just for the record, I'm Alia Smith here on behalf of ABC and NBC for access to sealed records. And I won't repeat what's in our papers, other than to say I read the Commonwealth's opposition yesterday.
Right.
And, I don't think that they offered, the compelling reasons that are necessary to seal, in a public criminal trial. The fact that the litigation was concluded in the Daily Press case, which is one of the main authorities that we relied on, I don't think is a distinction because the harm that they're claiming here is not to do with jury tampering. or jury impact. And same with they try and distinguish the press enterprises cases because in the press enterprise cases, the Supreme Court was dealing with the sealing of a whole entire trial.
Being closed, correct.
Correct, and that's true. And I appreciate very much that most of this trial has been completely open.
400 exhibits and televised, so.
Exactly, and the exhibits available on the internet. But I think the point of the press enterprise and Globe newspapers and all the Supreme Court cases is that every aspect of a criminal trial needs to be open, and if it's not, the sealing has to be justified by on-the-record findings of a compelling interest, and I don't think that's been done here.
Okay, all right, thank you, ma'am. Did you want to respond? I did read your opposition
We
brief.
would submit on our brief.
Submit on your brief. Did you want us to respond, Mr. Carroll? You join your microphone, just.
Your Honor, I would join in the Commonwealth's position.
All right, thank you. Okay, you can stay right there. That's fine. All right, so the ruling on the media motion, non-parties ABC and Dateline have moved to unseal certain exhibits admitted during this trial. The court fully recognizes and respects the First Amendment and the fundamental principles of transparency in our judicial system. These proceedings have at all times been open to the public and the media has not been denied access to any hearing or trial testimony in this case. At the same time, the court does not take the sealing of documents lightly. When considering sealing or unsealing, the court must balance the public's right of access against other compelling constitutional and statutory interests. Here, the constitutional and statutory rights of crime victims. Article 1, Section 8 of the Virginia Constitution, entitled Rights of Victims of Crimes, and Code 19.2-11.01, entitled Crime Victim and Witness Rights, require that crime victims be treated with dignity, respect, and sensitivity, and that their privacy be protected to the extent permissible under law. Victims are defined in relevant part to include family members of homicide victims, including spouses, parents, children, and siblings. As the Supreme Court recognized in Globe Newspaper Company versus Superior Court, the First Amendment right of access to criminal trials serves the important purpose of protecting the free discussion of governmental affairs. However, that right is not absolute. It may be limited where there is a compelling governmental interest, and any limitation must be narrowly tailored to serve that interest. The court finds that unsealing these materials would add little, if anything, to the public's understanding of the judicial process, while substantially infringing upon victims' constitutional and statutory rights. Here, the court finds that the protection of victims' rights constitutes a compelling governmental interest. That interest necessarily limits the public dissemination of graphic depictions of deceased victims, nude victims undergoing life-saving measures, and autopsy images, particularly where such materials would be available for permanent public distribution, download, and reproduction worldwide. The First Amendment does not require the court to permit the exploitation of crime victims or their families by releasing graphic images of their loved ones' bodies for purposes unrelated to public oversight of the judicial process. The victims in this case were a mother, daughter, sister, and a son, brother, and grandson. Their surviving family members' constitutional rights must be considered and respected. This remains a public trial. Of the exhibits admitted into evidence, approximately 400 exhibits are unsealed and publicly accessible on the court's website 24 hours a day. 74 exhibits were placed under seal. The court has reviewed each sealed exhibit admitted in this case to ensure that sealing was narrowly tailored and justified. I will note initially that one category of material referenced in the motion, the co-defendant's interviews with the Commonwealth, were never admitted into evidence and are not part of the court's record in this trial or any pretrial proceeding, okay? Those materials remain in the possession of the parties and are not subject to unsealing by the court. Additionally, the minor child's interview was sealed pursuant to a pretrial motion due to the presence of a minor victim, and that sealing remains appropriate. With respect to the sealed body-worn camera recordings, the moving parties requested that the court redact or excise portions depicting victims' bodies and release the remainder. The court received these exhibits in their entirety as evidence. It is not within the court's role or technical ability to edit, splice, or alter admitted evidence, and the exhibits must be considered as they are entered into the record. All sealed exhibits were sealed pursuant to motions agreed to by the parties at the time of admission. For the record, the court will now go through each sealed exhibit and state the basis for sealing. In doing so, the court does find that certain sealed exhibits do not implicate victims' rights and therefore will be unsealed, okay? So I'm gonna go through it and I'll give you a copy of this.
No, I appreciate that. And can I just be heard on for one moment on the body-worn camera footage?
You can, but I'm not gonna change my mind. Okay. All right, so would you not rather do, okay, good, okay. So let's go through the sealed exhibits. All right, number 4 is a body cam of Officer Hugh. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. A recently sealed number 5 is a picture In the far right corner, you can see Mr. Ryan's body. Number 6 of the Commonwealth's evidence, body cam of Officer Beckner. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Number 8 is a photo from the still body cam, and it's of the victim's body. Number 9 is also a photo from the body cam of the victim's body. Number 10, the body cam of Officer Gibbons. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Commonwealth's Exhibit 11, the autopsy report will be unsealed. Commonwealth's Exhibit 12, the autopsy report of Mr. Ryan will be unsealed. Number 11 was Ms. Banfield. Number 13 is a photo of Joseph Ryan's deceased. Number 15 is a photo of Joseph Ryan deceased. Number 20 is a photo of Joseph Ryan deceased. 22 is a photo of an autopsy of Ms. Banfield. 23, 24, 25, 27, 28, 29, 30, 31, 32, and 33, and 34, 35, 36, 37, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, and 49 are all photos of the autopsy of Ms. Banfield. Number 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, and 71, and 72 are all FetLife conversations which will be unsealed. Number 98 is a photo aerial view of the house, but Mr. Ryan's body is in the photo. Number 9, a photo of Mr. Ryan's body on the floor. 100 is a photo of closer up of Mr. Ryan's body on the floor. 101 is also Mr. Ryan's body. 101A is that same photo with annotations. 101B is the same photo with annotations. 123 is a photo of Joseph Ryan's body. 123A is the same picture with annotations. 123B is the same picture with annotations. 124 is also a photo of Joseph Ryan's body. 170A is a photo of 171 with annotations, which is the picture of Joseph Ryan on the floor deceased. 172 is a photo of Joseph Ryan's as well on the floor. 174A is that same photo with annotations. 181 is a photo of Joseph Ryan's body. 221 photo is of Joseph Ryan's body. 221A is the same photo with annotations. 241 is a photo of the body-worn camera, a still photo with the victim, Mr. Ryan, on the carpet at the crime scene. As far as defense sealed exhibits, the body cam video of Officer Palmer has the body of both Joseph Ryan and life-saving measures being taken from Ms. Banfield at the crime scene. And number 87 is a body cam video of Officer Casanova without audio, and the minor child victim is present for a significant portion of the video. And 119 is a Gmail log for FetLife, which I will unseal. So I will give you a copy of those, and I'll highlight the ones that I'm unsealing. They're already highlighted.
I appreciate that very much. And just for the record, I'd like to add that in the Knorr case that we cited,
Sure.
The court did order the availability of redacted video and documentary records. And in the AP case from the Fourth Circuit, the court held that administrative burdens are not a sufficient compelling reason to keep things. And so I really feel like, there's a way that public can have access to some of this, even if they don't have the specific, very graphic images.
And the exhibit is the exhibit, and I take the exhibit as it is. All right? Thank you very
Understood.
much for
Thank you,
your
Your
motion,
Honor.
and have a good day, Ms. Smith. All right, do we have anything then until 10 o'clock?
No, ma'am.
All right, I will go ahead and get the instructions put together in the order I'm going to do them, get a copy of them, and if you want to stay here, I'll get you the copies so you can be prepared for your opening statements, okay?
Thank you.
All right, thank you.
All rise. Kenny Asperati preside. Please be seated and come to order.
All right. So there was a little
Blip, Judge.
blip, but we seems to have taken care of it. We got your clean parts now, and then you had the 20 that you wanted to put the two together, which, if you want to take a look at it,
Yes.
if you want to approach.
Yes, ma'am.
just- You wanted to add 20, but you had two 20s. So we combined them, Shannon combined them for you. Does that,
Yeah,
and there's no objection to 20?
no, ma'am.
All right. So what we'll do, no problem. So what we'll do, this is the order I'm going to read them in for the record, and we have copies for the attorneys and for the court reporter for right now. Then we'll get copies for the jurors as well. All right, so the jury instructions will be read, instruction A, C, D, E, U, V as in Victor, L, I, M, F, G, X, N, O, P, T, 2, 4, 10, 12, 16, 36, and 20. Okay? All right. Is there anything else before we bring the jury out?
No, ma'am.
Okay.
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 Okay. I think this one is on.
Good morning, ladies and gentlemen. So juror number 2, I'm going to have to put you on the payroll. You keep that door open every time you come back. I really appreciate it. All right, ladies and gentlemen of the jury, you now have heard all the evidence in this case. All right, before the lawyers make their closing arguments, the court will give you the instructions of the law that you are to apply in deciding this case. Since it's been quite a while since I gave you the preliminary instructions, I want to remind you that in their closing arguments, the lawyers will refer to the testimony and other evidence that you will have heard, but what the lawyers say in their closing arguments is not itself evidence. Their statements are only their recollection of what the evidence in the case was. It is your collective recollection as 12 jurors of what the evidence in this case was, which shall govern your deliberations. In addition, remember your notes should be used only as an aid to your memory. You should not give your notes precedence over your independent recollection of the evidence, and you should rely on your independent recollection of what the evidence in the case was, and you should not be unduly influenced by the notes of other jurors. In addition, a reminder that the court has sealed the names of the jurors for a year. Just wanted to make sure I remind you of that. Okay, as far as the jury instructions are involved, you'll be able to take these written jury instructions into the jury room with you, and we'll make copies for all 12 jurors, okay? So you don't need to take notes on them right now, but I would ask for your attention when I read them, okay? With respect to the instructions I'm about to give, you might notice that at the top of them, some of them are numbered and some of them are lettered. You not have to concern yourself with that. You're just looking at the body of the instruction themselves, okay? Some of the instructions may appear to be in conflict. This is because the court cannot predict your findings of fact. Therefore, the court must instruct you, the jury, on the applicable law under both the Commonwealth's case and the defendant's theory of the case, okay? Brendan Banfield is presumed to be innocent. You should not assume that he is guilty because he has been charged and is on trial. This presumption of innocence remains with him throughout the trial and is enough to require you to find him not guilty unless and until the Commonwealth proves each and every element of the crime beyond a reasonable doubt. This does not require proof beyond all possible doubt, nor is the Commonwealth required to disprove every conceivable circumstance of innocence. However, suspicion or probability of guilt is not enough for a conviction. There is no burden on Brendan Banfield to produce any evidence. A reasonable doubt is a doubt based on your sound judgment after a full and impartial consideration of all the evidence in the case. Any fact that may be proved by direct evidence may also be proved by circumstantial evidence. That is, you may draw all reasonable conclusions from the evidence. You may convict Brendan Banfield on circumstantial evidence alone, or on circumstantial evidence combined with other evidence if you believe from all the evidence that he is guilty beyond a reasonable doubt. When the Commonwealth relies upon circumstantial evidence, the circumstances proved must be consistent with guilt and inconsistent with innocence. It is not sufficient that the circumstances proved create a suspicion of guilt, however strong, or even a probability of guilt. The evidence as a whole must exclude every reasonable theory of innocence. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. You may consider the appearance and manner of the witnesses on the stand, their intelligence, their opportunity for knowing the truth and for having observed the things about which they testified, their interest in the outcome of the case, their bias, and if any has been shown, their prior inconsistent statements, or whether they have knowingly testified untruthfully as to any material fact in the case. You may not arbitrarily disregard believable testimony of a witness. However, after you've considered all the evidence in the case, then you may accept or discard all or part of the testimony of a witness as you think proper. You are entitled to use your common sense in judging any testimony. From these things and all the other circumstances of the case, you may decide which witnesses are more believable and weigh their testimony accordingly. If you believe from the evidence that a witness other than Brendan Banfield previously made a statement inconsistent with his testimony at this trial, the only purpose for which that statement may be considered by you is for its bearing on the witness's credibility. It is not evidence that what the witness previously said is true. The defendant is charged with the crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred within a 3-year period. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. The defendant is charged with the crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred as part of the same act or transaction. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. Willful, deliberate, and premeditated means a specific intent to kill adopted at some time before the killing, but which need not exist for any particular length of time. A willful act is one done with a bad purpose or without justifiable excuse, or without ground for believing it is lawful. A willful act is intentional, or knowing, or voluntary, as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that the particular conduct will likely result in injury or illegality. To prove the charge of murder, the Commonwealth does not have to prove a motive for the killing. The presence or absence of a motive may be considered in arriving at your verdict. Brendan Banfield is charged with the crime of using a firearm while committing or attempting to commit murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that Brendan Banfield used a firearm. And number two, that the use occurred while Brendan Banfield was committing or attempting to commit murder. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find Brendan Banfield guilty. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. A firearm is any instrument that is capable of expelling a projectile by force or gunpowder. A firearm is also an object that is not capable of expelling a projectile by force or gunpowder, but gives the appearance of being able to do so. The existence of a firearm may be proved by circumstantial evidence, direct evidence, or both. Brendan Banfield is charged with the crime of child endangerment. The Commonwealth must prove beyond a reasonable doubt the following elements of that crime. Number one, that Brendan Banfield had custody of Valerie Banfield, who was a child under the age of 18. And number two, that he willfully or negligently caused or permitted the life of such child to be endangered. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt both of the above elements of the crime as charged, then you shall find Brendan Banfield guilty of child endangerment. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. The fact that Brendan Banfield has been indicted by a grand jury is not evidence against him, and you should not consider it. If there is concert of action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participated in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be discarded. You may infer that every person intends the natural and probable consequences of his acts. The Commonwealth bears the burden of proving beyond a reasonable doubt the identity of the defendant as the person who committed the crimes charged. If the Commonwealth has not met this burden, you must find the defendant not guilty. You may consider the character of the defendant when proven by the evidence, whether good or bad, along with the other factors and circumstances in the case in determining his guilt or innocence. The statements presented to you as having been made by the defendant are submitted for your consideration along with all the other evidence. The weight, value, credibility, and reliability of those statements are questions for your determination. If you believe from the evidence that the defendant previously made a statement inconsistent with his testimony at this trial, that previous statement may be considered by you as proof that what the defendant previously said is true. Juliana Perez Magalhaes has testified that she was an accomplice in the commission of the crime charged in the indictment. While you may find your verdict upon her uncorroborated testimony, you should consider such testimony with great care, and you are cautioned as to the danger of convicting the defendant upon the uncorroborated testimony of an accomplice. Nevertheless, if you are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt, the defendant may be convicted upon the uncorroborated evidence of an accomplice. If you believe that the defendant was without fault in provoking or bringing on the killing of Joseph Ryan, and if you further believe that the defendant reasonably feared under the circumstances that they appeared to him, that he or others were in danger of being killed or that he or others were in danger of great bodily harm, then the killing was in self-defense and you should find the defendant not guilty. The defendant contends that he acted in defense of another person. Under Virginia law, this defense is governed by the same principles that apply to self-defense. Number one, burden of proof. If the evidence raises a reasonable doubt as to whether the defendant acted in lawful defense of another, the jury must find him not guilty. Number two, reasonable belief of imminent danger. The defendant must have had a reasonable belief that the person he sought to protect was in imminent danger of bodily harm. All right, closing arguments.
Thank you, Your Honor. And if we can have the display for the jury activated from our table, and it does include sealed exhibits, so we'd ask it not be displayed to the gallery.
Just to the jury and not
Yes,
to the
please.
gallery.
Thank
Yes,
you.
yes, ma'am.
You good? Okay. Good morning. Thank you so much, not just for what you're going to do today, but for all of the time that you have spent carefully considering the evidence that we've been able to put before you, for the attention that you've paid, for the notes that you've taken, for the time that you've given up away from your daily lives, your jobs, and your families. Without your work here, Christine Banfield and Joseph Ryan would not be able to find justice. So thank you. The judge has read the instructions to you. They'll go back to the jury room with you, and you're going to have those as your guide in making your decision. I would draw your attention to the fact that you've been given 2 counts of aggravated murder, 1 count of use of a firearm in commission of murder, and 1 count of child endangerment. Talking first about the aggravated murder instructions. They have 3 parts. You'll first need to find that Brendan Banfield killed Christine Banfield and Joseph Ryan. You'll need to find that those killings were willful, deliberate, and premeditated. You'll need to find for one of the counts that those 2 murders occurred within a 3-year period, and for the other count, that those 2 murders occurred within the same transaction or occurrence. We know that they were killed during the same event within the Banfield residence, so that should knock that one out for you. 3 years, pretty simple as well. We know that they occurred on the same day. It's the first element that we're going to talk about, that Brendan Banfield killed both Christine Banfield and Joseph Ryan. We know that on February 24th, 2023, he executed his plan to murder his wife and an innocent stranger. He was in love with Juliana. He can pretend that this was a fling, an affair, he'd had them before, no big deal. He was in love with Juliana. He was afraid of losing her. He needed to get rid of his wife so that they could be together. so that they could marry, so that they could have those babies that he was picking out names for. Juliana told us how the plan was crafted and how it played out that morning in the Banfield house. But you've heard directly from our detectives and our experts the uncontradicted evidence of Brendan Banfield's culpability. You needn't rely only on Juliana's story. There has been a plethora of evidence to help you meet your burden in this case. Let's walk through just the highlights. Our digital evidence. While the digital evidence cannot tell us definitively who was behind the screen, we heard that a bunch. We know that to be true. What it can tell us is that Brendan Banfield and Juliana Perez Magalhaes are more likely to be the ones to have set up Joe Ryan to come into the house to fake rape Christine on February 24th. There is no digital history, none, of Christine Banfield using dating sites, fetish sites, searching for pornography, talking to other men prior to the January inception of this scheme. Brendan told you that more than 10 years ago, there were incidents of affairs involving rough sex. But you have zero evidence to corroborate that self-serving statement. Think about the 2 days of Mr. Litsky's testimony for the defense and the 3 times that Detective Miller was called to this stand. If there was one scintilla of evidence that supported these claims of infidelity, of interest in sexual violence, don't you think you might have heard about it? The FetLife and Telegram contacts all occur on Christine's laptop, frequently while her phone is in use with something completely innocuous. You remember the frozen tickets, the Lululemon shopping, the family vacations the day before the murder? 2 devices, 2 different people. The FetLife and Telegram usage only ever occurred when Brendan Banfield and Juliana Perez Magalhaes are in the home. Is it at all plausible that this woman wouldn't take advantage of an empty house to engage in her plans for adultery? That on the 2 weekends that her husband and the nanny are out of the house, those are the 2 weekends where we see 0 FetLife activity, 0 Telegram activity? Let's look at the chats themselves. Slide 1. How many potential targets were turned down by Juliana and Brendan because they wanted to meet in person first? Because they wanted to talk on the phone? Because they wanted pictures that included Christine's face? Does this make any sense for someone seeking a new relationship in an area of sexual exploration that would be new to them? Why would the real Christine Banfield have been concerned about taking these safety precautions? For that matter, why would the real Christine Banfield have been searching for someone who was willing to engage in knife play when she had a blood clotting disorder? Why would Christine use a phone from a gym bathroom, a photo from a phone taken in a gym bathroom when she has all of these far better pictures available? That one keeps stumping us. There are so many more whys, and I'm sure you have plenty of them in your own heads, but the answer is the same to all of these whys, because it wasn't Christine. It was Brendan Banfield with the help of Juliana. Let's talk about our physical evidence. You heard from Detective Leach, Dr. Kessler, Ms. McCarthy, Dr. Greenspoon, Ms. Colombo. She was up there forever with all those lab sheets. They gave us a million things to think about. Slide 4. Christine Banfield died as a result of 7 stab wounds to her neck. She suffered massive blood loss. Next, the knife Brendan used to kill her was a kitchen knife with an approximately 4-inch blade, the kind you use for chopping up vegetables. This was the knife that Joe Ryan brought because Anastasia asked him to. This was not the killing knife that Brendan Banfield had envisioned for his scheme. Next. Joe Ryan was shot twice. Once in the head by Brendan Banfield, incapacitating him. A second time by Juliana in the chest, tearing a large hole through his heart and lodging in his spine. His wounds were rapidly fatal, according to Dr. Kessler, and we saw that there was little to no blood from the chest wound. Iris Daly-Graf told you that he would have been incapable of movement following that second shot. Next. We saw evidentiary confirmation of the affair. The semen stains on Juliana's bed sheets. We also saw the photos of Juliana's clothing moved into the primary bedroom when the search warrant was executed in October following the murders. We saw the photos of Brendan and Juliana together, both before and after the murders. Her photos from her Instagram, their family photos in the bedroom after the murder. We saw the records from the shooting range for the purchase of the gun and the training of Juliana to shoot it. Slide 8. We saw the deactivation of the automatic locking feature on the front door at 5:47 a.m. the morning of the murders, done from Christine's phone by the person who knew how the locking system operated, Brendan Banfield. We saw Christine's phone turned off at 6:46 a.m. and hidden in a drawer in a bar table in the kitchen. This is just not where you keep your phone. This is not where we heard that this woman kept her phone. This is not where a person who's about to engage in potentially risky behavior puts her source of help. A floor away, turned off, in a drawer, off to the side of the kitchen. Just doesn't make sense. We saw Brendan Banfield drive to McDonald's and hang out, waiting for the call from Juliana. We see their call records, 10 and 11, between Juliana, Christine's phone, which is turned off, Brendan, Christine's phone, which is turned off. They're creating a record. It's a plan. It is premeditated. We see this false attempt to check in on Christine so that they can tell the story to the police when they arrive, that they did everything they possibly could. Next, we see the lock at the top of the basement door that Brendan Banfield did not think to engage to protect his daughter. Even under his own version of this event, he agrees he didn't think about it. He left his 4-year-old child in the basement with guns out, stranger in the house, and something happening that caused him to be concerned. We heard the 911 calls. We have a hang-up at 7:47 with Joe moaning in the background, and then a 15-minute gap before anyone calls 911 back. 8:02, 15 minutes between when someone in that house thought the police should be there and when they finally asked for help. We saw the body-worn camera and the photos from the scene. Blankets piled near the bodies. Brendan Banfield kneeling on this blue towel. The towel that has very little staining. Completely inconsistent with having been used to stop the flow of blood coming from Christine's neck. We heard that the carpet was soaked through to the subfloor. We saw Brendan Banfield's handcuffs that he didn't use. Magazines full of bullets he didn't shoot, collected from him after the murders. And finally, the blood evidence. You heard from Lieutenant Giacchio and former Deputy Chief Bruce that it was Iris Daly-Graf's report that finally pushed this case over the edge and brought the charges against Mr. Banfield months before Juliana decided to flip. That's how strong this evidence is. That's how reliable this evidence is. Ms. Daly-Graf walked us through so many inconsistencies in this scene. proving that it had been manipulated. And you heard absolutely nothing from the defense about this evidence. Mr. Banfield gave you zero explanation for any of this evidence. Slide 15. They have provided no explanation for Christine's blood smeared on the right hand of Joe Ryan, leaving voids between the fingers. They have no explanation for the blood smeared across the top of the right onto the left, leaving that void on Joe Ryan's hand where they had been overlapping. Next. For that matter, you have no explanation from defense for how his hands came to be in that position, neatly folded on his chest, covering the bullet wound that penetrated his spine, immobilizing him. How could that have happened if you are to believe Mr. Banfield? There's been no explanation for the bloody hand-like smears on Joseph Ryan's jeans containing Christine Banfield's DNA. There's been no explanation from defense for how his jeans ended up bunched under his rear. Next slide. There's been nothing to tell us why a mixture of Joseph Ryan and Christine Banfield's blood, a mixture, could possibly have been on the inside of his waistband at the buttonhole, on the button, and on the zipper. Nothing from the defense to explain how Joe Ryan could possibly have manipulated his pants after being shot in the head, given that no other bleeding wounds were present. If his blood is on those pants, on that button, on that zipper, he was bleeding when they were touched. How could he, Joseph Ryan, have been the one to touch his button, his zipper, the waistband of his pants, to pull them down in that fashion? Brendan told you he never touched Joseph Ryan. And yet we have distinctive finger-shaped parallel lines on Joseph Ryan's arm and small circular stains consistent with blood having been dropped from above while Joseph Ryan lay on his back. Next. And then there's the blood on Joe's hip. Blood that traveled onto his body and then ran down to the floor with the assistance of gravity while he lay prone. It couldn't have come from his chest. That wound barely bled. He was laying down when blood was shed. Makes it pretty impossible that he stabbed Christine Banfield. Next. On the other hand, Brendan Banfield has cast off on his jeans. He has blood all over his hands. The blood stains on the backpack don't line up with the position of its contents. The blood on Joe's face is not consistent with his final position. And I'm sorry, I'm back to Joe's hands. This scene was manipulated. And it wasn't by Joe. It wasn't by Christine. And according to him, Juliana didn't do it. You have zero explanation from the defense as to how all of this blood evidence can be as it is. The Commonwealth gave you an explanation. Brendan Banfield and Juliana Perez Magalhaes colluded to kill Joseph Ryan and Christine Banfield. That makes sense. They created accounts, they chatted up potential victims, they got Joe Ryan into the house, and then they shot him. Brendan stabbed Christine, let her bleed out on the floor, and then dripped, smeared, and wiped her blood on Joseph Ryan's body to make it look like he had attacked Christine. Then they called the police. Brendan let Juliana take the fall, and it took a little bit of doing, but here we are, and it's his turn to be held accountable. All of this evidence can leave you with no doubt that Brendan Banfield killed Joseph Ryan and Christine Banfield. That is the first element of the aggravated homicide statute. The hard work is done. Element 2, that the killing was willful, done with a bad purpose, intentional, and deliberate. There can be no question in your minds as to the intentionality of this act, the deliberateness of this act. You must also find that it was premeditated, that at some point before the killing, he decided to kill Christine and Joe. I believe that we presented you with that evidence as well. For one of the offenses, you find that he killed 2 people within 3 years. As we've identified, same day, definitely within 3 years. For the other offense, you find that it was 2 people killed during the same transaction or occurrence. They were both killed in the room as part of the same plot, by the same person, same transaction or occurrence. The second offense is for the use of a firearm in the commission of the murders. We know from our experts that Joe Ryan died of his multiple gunshot wounds, one of which came from Brendan. If you have any question about whether or not Brendan can be held responsible when Juliana also shot Joseph Ryan, you'll have instruction O, that is concerted action. So I'm going to read to you what it says. If there is concerted action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participate in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. Virginia makes it easy. Translate. If you think that Juliana Perez Magalhaes and Brendan Banfield were working together to kill Christine and Joseph Ryan, then Brendan can be responsible for Joseph Ryan's death, regardless of which bullet did the most damage. It's not a test of either or. They were working together. That makes him equally responsible. The last charge is the endangerment to Valerie. So while in his custody, that the defendant willfully or negligently caused or permitted the life of such child to be endangered. He made it out to be Juliana's idea, but he brought Valerie into that home. He left her in the basement, knowing that Joe Ryan was upstairs. He left her in the basement while he shot and killed Joe Ryan. He left her in the basement while he stabbed his wife. He could have locked the door. He could have done this on a day she wasn't home. He could have made arrangements for someone else to have her overnight. But that didn't work with his plan. So he's guilty of this offense as well. I appreciate, again, all of the attention that you've given. I appreciate, again, all of the hard work you're about to face. Please be thoughtful in your deliberations. But at the end of the day, I don't think that there can be any reasonable doubt that Mr. Banfield has committed each and every one of the offenses that we have put before you today. Thank you.
All right, thank you. Cross-examination, Mr. Chair. I'm
Thank
sorry,
you.
closing arguments?
Your Honor, may I bring a bottle of water up in front of the...
You can.
Thank
You
you.
just need to get the microphone.
It's on. Yeah, it's under something.
Good morning, ladies and gentlemen. Can you hear me? That's been a little bit of a problem, but I have it right on me at this point. I join in the Commonwealth's thanks for your attention, for the time that you've put into this. I intend to present to you with highlights of many of the things that we went through, but I can assure you I'm not going to be going through the evidence that's already been moved in. And it took a long time, and you were very patient, and everyone was very patient.
I'm sorry. Yeah, I was
Is that better, Your Honor?
Okay, just a little further up.
Can everyone hear that? Okay. I'll try to speak a little louder. Ladies and gentlemen, I join in thanking you for your time, for your attention. You could see over the nearly 3 weeks that everybody was attentive, and that's something that is something that's crucial to this process, and so I thank you. When my children were younger, I used to walk out of the house and tell them, I'm going to defend the Constitution. They didn't have any idea what that was, and oftentimes that became, okay, whatever, Dad. I was a prosecutor then. I was a prosecutor in Fairfax County. And what that meant to me was you presented a case, no matter who it was, you presented a case where you looked at all possibilities and you looked at all evidence to determine and to make sure that you were pursuing someone that the evidence would support. In this case, this was quite unusual. When we first met for the initial opening, I talked to you about some things that I thought you should look into. I thought that you should have an ear towards what is it that they're going to present as evidence. And even I was surprised that the evidence that ultimately was presented by the Commonwealth was actually from my case. The only people that were called to testify from the Commonwealth's case in chief were for body cam video, police officers, a couple of those, and Detective Terry Leach. And he was the one who identified all of the scene photos. He identified many of the pieces of evidence that were brought in. And he was able to talk a little bit about things such as the blood stains on the gun, the blood stains next to the bed. And what he told you, ladies and gentlemen, and this was the extent of, I think, their testimony in their case, was that there are numerous things within this scene that we can see in pictures, but they were never tested. There are numerous things that became the centerpiece of the fantastic story that the Commonwealth tells, yet they were never tested. For example, if I were to have the opportunity to cross-examine, say, the chief detective of this case, I might ask, why wasn't there fingerprints done, or even DNA, of this gun safe that we hear about? We hear Juliana goes into the back bathroom and talks about getting a gun. It changes a little bit over time, but if someone had said they went to the gun safe, because we're talking about guns, we're talking about shooting, why wouldn't there be some sort of evidence to either corroborate or preclude that possibility? I asked Detective Leach, he says, well, it's really up to the forensic examiners. They make the decision. In looking at the scene, you'll notice in the body cam video that you're going to be reviewing, there's a point when first responders come in and you see Brendan kneeling down next to his wife, rendering aid. He just shot Joe Ryan. He testified yesterday, he puts the gun down to his right, which is where his holster is. And he also indicates to you in his testimony yesterday that he moves the knife away from Joe Ryan. The staining on the bed where my client put the gun for the first responders, because whenever there's any sort of a shooting, you have to make sure that you are nowhere near the gun in the event that you're perceived as someone who's hostile. He puts it to the corner of the bed, and the questions that remain were, did anybody ever test the blood on that gun? And you hear from Detective Leach, you can't do that. It was already test fired, and now would be potential for contaminant. Now, we didn't test the stains down on the floor where the gun was lying in before it went up on the bed. And we didn't test the gun, which appeared to be something that a serologist could just take a swab of. Yet there's some significance placed on the fact that there was a blood stain where the gun was when it had been sitting in a puddle. And so that actually was tested. In terms of the blood stain pattern analysis, which appears to be the Commonwealth's main focus of the case now, there are questions about many of the things that Ms. Sand says were never tested. And so the conclusions that are being reached in terms of Brendan Banfield did this, he did this, he did this, based upon whatever blood analysis, is oftentimes not considering the fact that it was never tested. We don't even know whose blood it was. Those kind of things are important. And so let's go back to defending the Constitution. When you are charged with presenting a case, and I chuckle a little bit when Ms. Sands says, we haven't proved anything, we haven't shown any evidence. All we've done is show evidence. All we've done is try to get the truth out there. My client doesn't have to testify, yet he gets up there and he tells a story. He's a philanderer. We can conclude that. It's horrible. It's a horrible situation to be in. He had affairs. He accepted that. He told you, ladies and gentlemen, exactly what was going on and exactly how it went. On cross-examination, he admitted to communications that were provided, which were letters between he and Juliana when she was in jail. This is about the truth. In the beginning, you heard our duty is about fairness, our duty is about being just, all those sorts of things. Yet you don't put on any of your detectives. She's referring to the expert that they have that I called. I called 3 times, and you saw his demeanor. He was very uncomfortable. Why would he be uncomfortable? Why would he have been uncomfortable talking about his work? And we dug for it, and he ultimately said, the executive summary and the data remain the same. The only thing that changed is Juliana Perez Magalhaes' statement. Excuse me 1 second. So there, number 1, that's the first time that anyone in this case, which was when I called him, conclusively said the entire catfishing theory changed upon her plea deal. So let's talk a little bit about confirmation bias, or I think we referred to it when we were talking in closing, or when I was talking in closing, about a rush to judgment. You've heard from detectives from Fairfax County. Detective Smith came up and she told you the catfish theory started within weeks of the event. She says, that's not how we do it. We look to the evidence and we follow the evidence. seems like a pretty reasonable way to go. And that was something that I asked of pretty much everyone that was in some sort of investigatory capacity. That is the way cases go, is the evidence leads you where you're going to go. But lo and behold, what we find out is that that theory is being peddled by the two people in command staff, actually the three people in command staff that you also heard from. You heard from from Mr. Bruch, formerly Deputy Chief Bruch, that when Brendan Miller presented his findings, well, first of all, he said, I didn't agree with his report. And I said, well, what, if any, analysis of the raw data did you do in order to make that statement, I don't agree with this report? He said, well, it wasn't that. I don't know about the data, though he said he was a computer forensic PhD. He didn't take the time to do that. So I said, okay, well, did you ever have Detective Miller come in and walk you through it? Like, show your work? Well, we talked about it quite often, but did you, in fact, have him go through everything that he did to arrive at his work? No, we didn't do that. He speaks to Lieutenant Giaccio at the time, who appears to have a direct line to him, obviating anybody else within the command staff. And what you'll see, and you'll see it in the evidence, there are emails where soon after Juliana Perez Magalhaes changes her story, there are emails to Sergeant Ames. And you remember Sergeant Ames, he came to the stand based upon my subpoena and my calling him. And Sergeant Ames was not comfortable. And you could see any of these police witnesses are just not comfortable coming to the stand on my subpoenas and answering my questions. But he did answer them. And what you saw were emails. Those emails were essentially they were just kind of forwarding it up the chain so that his supervisors knew. And he was very candid about it. I was new. I wasn't sure how to deal with a situation like this. I'd never dealt with a situation like this. But what the situation was Detective Miller's executive summary being sent up the chain to Sergeant Ames, who was in a different division than Lieutenant Giaccio, saying there's different ways, there's three different emails that you'll see. Brendan Miller has got to look over this, and he's got to go line by line and explain how we got it wrong, things such as that. The final one is to Sergeant Ames. I can tell you that every single conclusion in his report was wrong. He's going to have to do something in order to, and it's kind of, essentially, he's going to have to change this report because it needs to conform with the proffer of Juliana Perez Magalhaes. So that's twice now. Two different people that I called to the stand that essentially confirms that everything changes when she comes in and testifies. Let's get back to confirmation bias, rush to judgment. When you have people in a supervisory nature, you have a command staff chain of command, and the highest people are pushing you on your work product, that's why you look like the people that are up here testifying, because they're sitting on the fence. They're sitting on a razor, and neither side is good for them. But they came before us and they testified, and they testified as to the truth. Detective Miller spoke the truth. and you could see it. Detective Miller, his work was concurred by Mr. Litsky, who you heard for quite often during this period of time. And it was peer reviewed and it was concurred by someone, a third party. You heard Detective Miller say, that's never been done in Fairfax County. You heard him say, I didn't ask for that peer review. He didn't know who asked for that peer review. Why would you want a peer review of something if it wasn't for it to change? So once again, not happy with that, not happy with the work product. There's nothing to indicate in Detective Miller's background anything but stellar expertise. But he wasn't introduced as an expert for the Commonwealth. Now, this is where this whole theory went wrong. They discredited him, they disregarded him, and they didn't listen to him. And that's a problem. That's a problem for their case. Because there are things in digital forensics that had he been involved with the group that was talking to Juliana Perez Magalhaes, he would have been able to guide them in terms of this is where the digital forensics is in conflict with you. And you heard me testify, or I'm sorry, you heard me ask questions of many of these detectives who might have been involved. Did anybody ever challenge her? Were you present when she recanted for the first time? Well, we couldn't ask that of anyone because the detectives that were in the room have not been called. The detectives that were in the room, I didn't call. And so we don't know anything, but we heard Detective Miller, and he had viewed it, and he said, when I asked him, were there challenges to what was said? He said, no, it was pretty free-flowing. To me, that tells you whatever the story you're telling us is great, because we're getting Brendan Banfield based upon that. Once again, confirmation bias. The first few weeks after the death of Christine Banfield becomes this theory of catfishing, which is what Juliana Perez Magalhaes provides to this. Now let's talk a little bit about digital forensics. And I'm not going to try to use the computer to show these to you because that was excruciating at times. But I think we've gone through it with significant enough detail that when you go back to look at the exhibits, and I'll tell you which exhibits if you wish to write them down, you're going to be able to see exactly what Mr. Litsky was saying. It's complicated. It's been complicated for me since the beginning, but it's not necessarily an easy grasp. But I would ask that you take the opportunity. You're going to have all this evidence to review this particular area. So some of you may have been asking about January, or may wonder about January 9th. That's a significant date in this investigation because that's the day when the Gmail account, called the suspect Gmail account, was started. Let's just look at how Juliana Perez Magalhaes managed this. Regarding the Gmail setup on January 9, 2023, Juliana told the Commonwealth that she was at the house with Brendan when she witnessed him create the Gmail account that was used to kick off the entire catfishing scheme. The Commonwealth took her at her word. The police didn't make any effort to corroborate her story. The one detective who stood up and said the evidence contradicted her story was transferred off the case. I think the words were from then Deputy Chief Bruce, "That guy will never work on another digital forensics case in major crimes as long as I'm here." He admitted it. There was no dancing around. He admitted it. So you have something that's in opposition to whatever the theory is that you're trying to peddle, and you're in the command staff, you're high up in the police department, you can just transfer them. And so it was from that point on, Detective Miller was of no benefit to the police because no one would utilize him once the stamp of disapproval had hit him. He was moved over to child sex. Juliana told the same story to you here in court, and it's a lie. The account wasn't created with Christine's phone. I'm sorry, the account was created with Christine's phone, not her laptop, which was the story that Juliana had told. Juliana wasn't even home. She hadn't witnessed anything. And you saw the presentation, and that would be, the evidence would be Exhibit 297, Exhibit 294, and Exhibit 295. They're all in relation. You'd be looking at the Google records, the T-Mobile records, and the subsequent map of where the location was. You heard from Mr. Litsky that the Gmail account is crucial. They all interact. The Gmail account is necessary to get the messages relating to the FetLife, and then the Telegram was created as part of this, whatever we want to call it at this point. Juliana made it up. She told the Commonwealth what they wanted to hear, and without question, they just took it as their story. She told this lie to secure herself a deal that benefited her. This one event relating to digital forensics is reasonable doubt, because every other event going forward requires Brendan, based upon her statement that she didn't have anything to do it, she didn't know how to do the Gmail account, she didn't know anything about the setup, requires Brendan to be involved, or Christine. So let's look at this. There was a period of time, and you heard evidence of it, Brendan wasn't at home. January 23rd, there was a Gmail login at 11:22. That's Defense Exhibit 245. FetLife was accessed. In the communications, you heard Mr. Litsky opine as an expert that catfishing is not a scheme where one talks about their husband or talks about how's your experience on this site. The catfishing in the truest form of the government's theory is we just want to get someone on the hook, and then person's gonna come, and then we're gonna do what we did in there in the house. It's not consistent with catfishing. And you'll see, based upon the records relating to January 23rd, There was only one adult in the home at that time. And that adult was Christine Banfield. January 30th, there are 2 Gmail logins. 10:36 and 11:03. Exhibits Brendan Banfield 251 and Brendan Banfield 252. Brendan wasn't home. That can be shown. So there are 2 adults in the house. Christine Banfield and Juliana Perez Magalhaes. Juliana testified to all of you. She doesn't know anything about the Gmail. She doesn't know how to activate it. Well, somebody activated it that day. Somebody logged in twice. And there are 2 adults in the house. Either Juliana's lying again, and she did figure out how to do Gmail, or this was Christine Banfield. Digital forensics, oftentimes, for people who don't understand it, will say things like, well, isn't it possible this? Well, you see what happens when an investigator is looking into, trying to get attribution. They're looking at all sorts of different data facts in order to make a determination, make an opinion. It's not as easy as saying, well, isn't it possible this? There's more to it. And once again, digital forensics is not being given the strength that it is due. February 7th, 2023, Gmail login at 10:02 p.m. There's only 2 adults in the house. Brendan Banfield can be identified as being out of the house, and one of whom says she never did anything with Gmail. That's BB 257. It's been presented to you. You can recollect what it was that was said, but what we know is that Brendan was out of the house. What we know is that Juliana was there, and we know that Christine was there. February 13th, 2023. There are logins in the morning in the 7 a.m. hour. Well, what we know from digital forensics is that Brendan left at 6:05. And at 6:12, he was at Tyson's Corner, based upon his E-ZPass records. At 6:17, he was already to Alexandria. And soon thereafter, he was in Cheltenham, which is the Federal Law Enforcement Training Center. They call it FLETC. Well, while he's on the road, while he's at the FLETC Training Center doing his training, there are 2 logins. And there are 2 possible adults there. Juliana Perez Magalhaes, who has said she doesn't know how to do that, and Christine Banfield. 2:17, you'll see Gmail logins at 11:19, 11:23, Exhibit 262, 263, same thing. 2 possible adults. Brendan Banfield was out of the house. One said she never did anything with Gmail. A fact that I think is very important in the discovery that was provided both to Juliana Perez Magalhaes as well as my client in preparation for her trial. FetLife was in the discovery, but Gmail was never in focus. Never in focus. So her testimony, there's a comfort level with FetLife because she saw it in discovery. She didn't see the Gmail. And isn't that a coincidence that when asked any details, she says, I don't know. When she says, I don't know, for 5 or 6 questions, I hope you recall it, I recall it vividly, she said, if you keep asking these questions, I'm just going to say I don't know. And she continued to do that. Were my questions challenging, like the kind of questions that a detective might do? No. We were just looking for details. We were looking for details because we wanted to try to iron out what are these situations here. She was unwilling. She didn't know, but she knew I was digging for something. But if you look at the way she testified to all of you in direct, she was led to a certain statement or a certain fact, and she stated it. In cross-examination, I asked anything about that. Do you know who was in the house? Do you know where you were? Were you on the phone on WhatsApp with Christine prior to that? Where were you located at the time that this call took place? I don't know. I don't know. If that's what it says, I don't know. You know, there were a series of similar answers. Once again, her role has grown in importance for this case. It's, along with Deputy Chief Bruce and Lieutenant Giacchio, she's pushing it on through her deal. Now, one of the things that I talked to you all about, and one of the lengthy cross-examinations was relating to a group of exhibits which were number 1 through number 69. And you'll see it. It was highlighted. I think you've seen it for a brief period of time, but we were moving along. Look at that. You'll see these are the personal letters that she would write to my client. And those personal letters, I believe, is the closest to the truth that you will have heard from Juliana Perez Magalhaes. She was in a situation which really was affecting her. And it would affect anyone. And she was telling you how she was feeling. She was telling you what she thought. There were things that were relevant to this case. They're trying to make me turn on you. I'm not going to do it. I don't have anything to say. There's nothing that I can do to help them with. And then you'd see letters as the time went on. I don't know if I can live like this anymore. I think it's better for me to end. And then as she gets closer to a preliminary hearing in April of 2024, you start to see real angst and real worry. And they're coming to her and asking her if she'll testify against my client, because that's what they wanted from the beginning. She was a pawn in trying to get to my client. You'll see this timeline in these letters. It goes toward July. July was the date of her first trial. And you'll see, and I'm not suggesting what she's saying about her lawyer is correct, but it was obviously something that was on her mind, and she didn't feel like she had the support. At that point, if you think about it, the only support that she was having was from Brendan. Brendan was not arrested. Brendan was there communicating with her. Brendan's mom was actually supporting her lifestyle in the jail in terms of commissary, things like that, and also supporting her by having paid for a lawyer. Around August, you'll see in these letters, it gets to be real despair. And then you can almost see hope just drop right away from her when she hears that Brendan's arrested. And then she testified. She went into the hospital from October 13th to October 23rd. And as soon as she's released and back to the jail, the deal is done. She's told, if you testify against him, we'll recommend time served disposition. She can go back to Brazil, be with her mom, create her new life. And we know a little bit about the new life that she's planning on creating. And you have it in the documents that are before you. She's been negotiating with people who are connected to Netflix. She's been negotiating with people who are connected to Hulu. She's been talking to every other news media, at first to try to see if they just put $50 into her commissary. But then she realized, hey, there may be something here. She's invented, she's going to try to write letters. She's going to try to write a book. She wants to have a documentary. She wants to have a series. And she's about to sign or about to agree when her lawyer steps in and says, don't sign that. And so around March of 2025, you see negotiations essentially end. The number was in the area of $25,000, and it was going to be sent to her mother in Brazil. It's a lot of money in Brazil. And so, where's the downside for her? Where's the downside for her? I mean, there are plenty of people who would make that decision, given the circumstances, given you're 2 weeks from the trial, when your attorney asks for a continuance. And oddly enough, he was asking to find a digital forensic examiner. If they'd done that, maybe that wouldn't have happened. Maybe they would have realized how strong the digital forensics examinations are. Her entire story has been bought and paid for. First, with her freedom, and then now a little bit on the back end. There's a jury instruction here that says something about corroborated, uncorroborated testimony, and you should be careful of it. Now, how did they try to corroborate her? So isn't this funny? They're trying to bolster the witness who's the centerpiece of their entire case. Well, they found something when my client was arrested on his laptop that said they'd just gotten vinyl light windows in December. So, sitting in the meeting with whomever, they say, can you tell us anything about these vinyl light windows? They're triple paned, probably really good. I wasn't there, I don't know. But the story she gave was that, fantastic. We got the triple pane windows because Brendan wanted to make sure you couldn't hear a gunshot in the bedroom. And and she says, he asked me to go outside and scream to see if the windows, and she says, I'm not going to do that. So she ended up staying inside and saying Brendan went out and screamed. Well, you heard the test. I mean, this gentleman from Vinylite Windows came in. They trotted him up there, and he said, "Yeah, you know, we met in January. That was when we first talked about this, and it wasn't just the windows for the bedroom, which is what Juliana said. It was the full windows, and then you saw an artifact on Facebook that is Christine Banfield actually talking to her neighbors about the numerous vendors that they had been working with to try to get a quote from December 2021. So this is well before Juliana came on the scene, but it's an opportunity to try to make her appear in the know, to corroborate her. Well, that was a disaster, and that didn't work. And you heard the gentleman, you know, what the life cycle of order to quotes to all those things, they were all done well before any sort of relationship started with Brendan. Confirmation bias. Rush to judgment. It continues on. Detective Leah Smith tells us the catfish theory was told to them within 2 weeks. She goes on to talk about the theory and investigation and the direction it was going in. During a period of time soon thereafter, Detective Miller tells of his transfer against his will because he was advised he'd never work on major crimes cases again. Sergeant Ames, after receiving communications from Lieutenant Giacchio, immediately sends it up the chain. Could be just the way he does things, or it could be, read those emails. Hey, I'm being asked to do this. I need some support here. When you have a theory that gets pushed from non-investigative command staff, and you have a theory that the investigators look at, then you create something called tunnel vision. And that tunnel vision, if you're following what essentially are orders, is to the exclusion of any other evidence, any other theory, such as maybe this is a rekindling of previous fantasies, and the guy who brought the knife to the house is the stabber. You can see how that theory is going to be pushed aside. And you can see how that's not very noteworthy for purposes of media or other attention. Once again, rush to judgment. Catfishing. If you're catfishing, meaning you're trying to get the one guy, Joe Ryan, to come to the house so that you can do this gruesome act. Why are you saying anything about, I can't have marks on my face or my body? If you're catfishing, why would that matter? It doesn't make sense. It's inconsistent. However, if you're interested in dabbling in this lifestyle or getting back into it, however you want to say, then that makes perfect sense. There's 9 different conversations on FetLife with different people. and you have all of the FetLife communications, and you can see, why would you have discussions where you're bringing things like no marks, anything like that? All you need is one if you're going to carry out what the government's theory is. Why would you give anyone details about your work or your home or your husband if you were catfishing? I mean, if it's truly catfishing, you're looking for the biggest pile of people that might be considered. If you're telling someone that you have a husband and you want them to come over to the house, why would anybody come? You're losing the potential people that you might want to have there who are violent or, love to do all the things that Juliana has said. Why would you do that if you're catfishing? It doesn't make sense. On February 13th, 2023, why would there be generic research on secure apps for communications? In fact, why was there even a need to transition to Telegram? Because if you're on FetLife, it's clear there are FetLife communications. And so in the world of catfishing, if you think about it, you want to do as few things that can get you caught. So what was the leap to Telegram? It doesn't make any sense. In fact, this whole theory doesn't make any sense. And the only way the government can make any sense of it is if Juliana Perez Magalhaes adopts their story once again. As late as February 19th, which would be 5 days before Christine Banfield's death. Under the government's theory, there were dates that were being explored with 5 different FetLife users. Why? If Joe's already coming, why? It doesn't make sense. It doesn't make sense. Juliana Perez Magalhaes is doing what probably anyone would do who's from another country, who comes here for an adventure, which is what au pair exchange is. It's essentially a cultural exchange. And the idea is you get to live in the country and you get to live like people in the United States. And then you go back at the end of your time. She knew at the point when she was hospitalized to the point of sickness as a result of what was going on in her life that she had to do something. And the Commonwealth and the police broke her. She turned down a misdemeanor, according to her, in January, on January 1st, and you'll see it in the communications. She turned down a misdemeanor, and all she had to do was testify against Brendan. In July, you hear her recounting her meeting with her lawyer, where her lawyer floats the idea, what about a manslaughter, time served, and you don't have to testify against Brendan. She agreed to that. That was never what they were talking about. That was never what they wanted to do. You heard from Sergeant Matt Nilsson, who briefly came in, and he was one of the homicide people during the time of the killing of Christine Banfield. He's since rotated out to another division. But he came in and he said, the whole goal of arresting Juliana was to flip her against Brendan. Once again, further corroboration. We knew it, we saw it from her letters, and now you have someone who was involved saying, yeah, that was what we wanted to do. That's why we did it. They broke her. In talking about the blood work and the blood testimony, it was suggested by the Commonwealth that we hadn't proven anything. The Commonwealth had not shown anything. Well, I beg to differ. You heard from Leanne Singley. Leanne Singley is an expert. She's an expert with tremendous credentials, and she's an expert in truth in terms of what she's allowed to say, what she can say, what she can't say. And she speaks to you in the language of bloodstain pattern analysis. She's not talking about possibilities, she's talking about facts. She's a scientist. Her counterpart from the Commonwealth was willing to entertain any possibilities. In fact, questioning of her was, well, isn't it possible this? Isn't it possible this? Isn't it possible this? And oftentimes you would hear her respond, well, that wouldn't be something that I would have expected to see, which is a very interesting statement if you think about it. What is it that she's expecting to see? Which makes you wonder, who's telling her what she should be seeing? And does it fit the narrative? So let's go to Leanne Singley. She tells you of the account of the events. Ryan stabbed Christine in the neck. Brendan shot Ryan in self-defense. Brendan rendering aid to Christine. Ryan moved toward Brendan and grabbed Brendan's arm. You see that in the videos. And Juliana shot Ryan to end the threat. What Leanne Singley tells you is all of the blood evidence supports this. Ryan brought the knife. That'll be Commonwealth's Exhibit 10. The knife has blood on it with Christine's DNA on the blade and Ryan's DNA on the handle. Ryan has Christine's blood on his hand as well as a puncture wound, which the medical examiner says is consistent with the knife. And if you look at the knife, it's described in the certificates of analysis as testing underneath the handle by the edge of the blade. And if you look at the marks on Joseph Ryan's hand, the medical examiner states that these wounds are consistent with that knife. Which reminds me, the medical examiner also said that Joe Ryan was capable of movement. And you can recall your own notes on that. That was very clear, which is in absolute conflict with Ms. Groff and is in absolute conflict with the Commonwealth's theory. She further goes on to say, Ryan has Christine's, the blood on his hand shows his hand was closed when the blood was deposited. That's that closed fingers we were talking about. That's what the Commonwealth was talking about in terms of having nothing going in between the fingers. That's holding a knife. That's how that happens, because you're holding it very rigid in order to do that. The bloody handprint on Ryan's thigh is consistent with him touching his own leg with his bloody hands. That's Ms. Groff. The stains on Brendan's jeans and shirt are what you expect he would get while giving aid to Christine. And we see it. We see it on the body-worn camera. We see it on the still shots. He's leaning down. He's down there on his knees. Interestingly, Ms. Groff says, all I saw was his hands around Christine's neck. I don't know that that's not accurate, but that's probably not what was really going on there, because everyone else said he was rendering aid. The police witnesses, who are more objective than the expert witness for the Commonwealth, all say that he was rendering aid. Testimony by Ms. Groff and the ME indicated that Ryan could move after the gunshot. And what's most important is that there's a DNA mixture of Christine and Ryan on the arm of the jacket where Brendan said he was grabbed. 3 times. 3 times when he was being told by the first responders, go into the bathroom. He said, they're asking, is he okay? He hit me on the right side under the shoulder blade by the arm. He said that. Then in the ambulance, you'll hear that. He says, when they're asking, are you okay? Are you okay? I don't think I'm injured, but he did hit me on the backside of my jacket. In the ambulance, they grabbed the jacket. And then when he was in the hospital, the doctor asks, and he says, he hit me on the back, but I'm not injured. The critical part of that is that the DNA mixture of Christine's blood and Joe Ryan's blood on the jacket was, if you were listening to my client yesterday, he tells you that that was Joe Ryan after he shot him. That mixture of blood with Christine and Joe Ryan himself had to be after Joe Ryan had stabbed Christine in the neck. And that's the way her blood would get on him in order to be able to get the back of my client's jacket. That's what Ms. Singley says. And that's why the Commonwealth is so intent on saying this had to have been on the floor, this had to have been on the bed. But there's no evidence to support that. There's a story to support it, but there's no evidence to support that. The evidence in terms of what happened in that room, and the crucial evidence is spot A on the back of the jacket, and you have it in evidence, and you also have it under Commonwealth's Exhibit 160, 161, and 167. Now, let's just talk a little bit about the prosecution's evidence. Brendan's DNA is not on the knife. That's also supported by those same forensics reports. He doesn't have any injuries to his hands. That was confirmed by EMTs. In fact, poor officer, I'm sorry, the young man who was 1 year on, I forget his name now, he was brought up to introduce his video and then was asked, well, why'd you let him wash his hands? And you can see my client, for a period of probably 40 minutes, is literally walking around, you know, in a trance from what he was just involved with, and he was walking around with blood all over his hands. And it was only after he was told that his wife had died, and the emotions that come from that, where he was blowing his nose and wiping his eyes and doing all those things, it was offered for him to wash his hands. But that appears to be some sort of a a horrible thing that this officer allowed him to do, and it was even an insinuation that my client was trying to cover something up. This was 45 minutes later. It wasn't as though he went into the bathroom and did it right there after being removed from rendering aid. Brendan's DNA does not show up anywhere on Joe Ryan, which is consistent with what he told you, which is that he never touched Joe Ryan. There's no indication that there was any sort of movement, and frankly, what's the possibility, I guess I'll use the same word, that a 185-pound man would have been moved if he was otherwise dead? It's not an easy task. And Brendan Banfield's an athletic guy, but I don't think he's up to moving 200 pounds in that sort of way. So that's an absolute red herring in this.
Mr. Carroll, do you have quite a bit more? I just want to give you a chance to take a break.
Probably about another half hour.
Yes, let's go ahead and take our morning recess for 15 minutes. Please do not discuss the case at this time and do not do any outside research. Just come back at 11:55. All right, 11:55. All right.
Thank you.
All rise.
Ready for the jury?
Okay. We're ready for the jury. All right, thank you. All right, Mr. Carroll, you can continue. Thank you.
Thank you, Your Honor. Ladies and gentlemen, we left off in the discussion of the bloodstain pattern analysis. And what was an interesting moment in terms of the experts was when there was talk of bloodstain inside the zipper and around that area. But if you look at the DLI report, which is number 169, you'll see in that report they were looking actually for touch DNA. They weren't actually looking for blood staining. They identified blood staining, but the whole point of it was to find Brendan Banfield's touch DNA on the inside of Joe's pants based upon some theory that he was either pulling the pants off or moving them or something like that. And that was one of the reasons why they went to a private lab to try to do that, and it didn't pan out. And you'll see the report. Now, in terms of the evidence on the bloodstain pattern analysis, let me just do a rundown. With regard to the knife, it was identified as being bloodstained. Leanne Singley said that. She negated the possibility of anything being wiped off, which might be one of the things that you might find in a situation of the nature of the government's theory, but she's negated that. That it contained DNA of Christine and Ryan, and Brendan was excluded. That Joe Ryan's DNA at the base of the blade, handle juncture, that was the testimony of Leanne Singley and also confirmed by the Division of Forensic Science. That Ryan had a puncture to the left thumb, that was Leanne Singley's testimony, as well as the medical examiner, Dr. Kessler, confirmed that. It was consistent with the knife, Dr. Kessler said, and it was consistent with the self-wounding that happens in situations involving stabbings. And you heard Leanne Singley touch on that, and she was able to kind of give you a more circumspect view of what self-wounding was. I think Ms. Groff talked about slicing, fingers or it sliding or something like that. What we were looking for, and what I think Leanne Singley was able to tell you, is that there are a wide variety of injuries that occur, but oftentimes the stabber is someone that's injured. And I think there were significant statistics that she talked about, which I won't try. You'll have to rely on your recollections regarding that. You saw on the body cam footage, as well as through Ms. Singley's testimony, that Brendan does not have any injuries on his hands. And Ms. Dolly's testimony indicates Ryan's right hand closed when blood was deposited on it. That's consistent with Ryan holding the knife when stabbing, causing blood stains. Joe Ryan, there's a lot to be said, and I think you've already seen pictures of it in this closing, of the 4 stains on Ryan's forearm. What hasn't been said is that they were not tested. Leanne Singley says they're not able to be classified. Ms. Groff disagrees, saying that they are drip stains. She needs to say they're drip stains, which Leanne Singley says you can't say because you don't know the position of the arm, you don't know where it was at the time the blood came out. It could have been something from a significant bleeder as he's standing up. It could have been from numerous other possibilities. But Ms. Groff classifies something that Ms. Singley says you can't classify without certain factors, suggesting that it's falling from above and has Ryan on the floor. One might think you'd find the source of whatever that blood is if you're to have tested the blood that's in question. That might give you a little more guidance. And I think that's one of the reasons Leanne Singley was unable to identify that. If it was from Joe, then she'd probably have some explanation for that as an expert. If it was from anyone else, that perhaps could be a different explanation. But now all we deal with are possibilities. And that seems to be the crux of how the Commonwealth is pursuing this case. They're not putting on any evidence in terms of their own investigators. They're not providing any concrete evidence as to what happened that day. And interestingly enough, the shift in the last closing argument was that I hadn't been doing that. And the defense hadn't been doing that. But I think we can all agree that we've called significantly greater number of police witnesses because we had to. Because we want the truth out here. I called my client, though he has the absolute right not to come up and testify. And he testified. And the relationship issues with Juliana Perez Magalhaes are touchy, and they're an awful story. But he sat there and he answered the questions. He was cross-examined. He answered those questions. We're bringing you the truth. We're trying in every way to get the truth. And many of the Fairfax County detectives have provided that, and that goes to their integrity. The genes, the touch DNA from the waistband zipper indicate Joe Ryan and Christine Banfield are the contributors. Brendan Banfield is excluded. All samples collected and tested on Ryan were from Joe Ryan or Christine. Brendan not identified as a contributor in any of them. Nothing in the materials reviewed gave any indication that Ryan was not the stabber. That was Leanne Singley's testimony. Brendan's jacket, blood on the rear of the right sleeve, DNA on exterior of right sleeve, mix of Ryan and Christine. Brendan indicates that Ryan grabbed his arm on Officer Beckner's video, Officer Baumler's video, in the ambulance, and also in the hospital. Brendan's jeans, the small stains on the thigh is consistent with cast off from the hands. That's Miss Dolly, Miss Groff. Brendan sat in the bathroom, if you look on the video, and the first responders arrived. He was basically told to sit on the tub, and you see him. when you look at that video and he's sitting there and he's just, hands down, not sure where his hands go, and he was watching as his wife was being tended to. The stains on Brendan's jeans are consistent with him kneeling at Christine giving aid. That's what the body cam video shows. Back to the digital forensics for a moment. February 19th was a critical day because that was the beginning of the Telegram account. Juliana says she watched Brendan. They stole the laptop and the phone. They deleted the two-factor authentication code, but the two-factor authentication code remains on the phone to this day. And this is Defense Exhibit 156. Is it possible that Brendan and Juliana did this without Christine knowing that a Telegram account was opened in her name? It's not, based upon this exhibit. Because if you look at it, and you can look at the message from Telegram, shows up right underneath a message from Brad of Inova PICU, and right above a message from Nicole at Inova PICU. It was done early in the morning. If it had been done by someone other than herself, as soon as she looks at that message from Nicole, she'd realize something's going on. I should check this out. Inconsistent with catfishing and consistent with someone pursuing a fantasy. February 23rd, we saw digital forensics evidence from the evening of February 23rd. We saw use of Christine's laptop for 90 minutes for resort searches, with a couple of minutes of Telegram use interspersed. The Commonwealth in cross-examination opined, well, wouldn't it be possible that even if you were sitting in the same room, that she could have gone away to go to the bathroom for 2 minutes? And I guess, in this world, anything's possible. Is it probable, however? And that's really the more germane point to this. The Commonwealth's, I guess, concern in cross-examination was confirmed, at least in terms of the room, when Brendan testified. And if you recall his discussion, we were talking about, we were already going on a cruise and we were talking about going to the Dominican Republic. We saw the calendar that showed the place, Royalton Resorts. We showed the searches that showed kid-friendly vacations. So we knew who was behind the keyboard, and Brendan knew who was behind the keyboard because he was there with Christine. And they were collaborating on the vacation research. Brendan was playing with Valerie, and Christine was on the couch with her laptop and her phone. That's the testimony. The device's symmetry and connectivity you heard about has the context to complete the entire picture. Juliana was not in the room, and this is supported by the analysis on her phone, showing a steady stream of messaging social media use, and Netflix at the same time that Telegram, FetLife, and the suspect Gmail account were being used by Christine. And finally, February 24th, Juliana was not awake and not out of bed based on her devices at the time she claimed to be watching Brendan Banfield sending messages in the kitchen. You heard Mr. Litsky talk about her Apple Watch. You heard him talk about her phone. We're showing when steps were showing, which would be an indication of someone moving. She had not moved for some time after the laptop was accessed. What we know from the testimony yesterday was that Christine Banfield had the laptop and the phone in her bedroom and was awake when he went up to retrieve Valerie. That is an artifact in the world of digital forensic analysis. And you'll see this entire exchange, Defense Exhibit 348, 349, 350. You'll see Juliana Perez Magalhaes' first steps at 626, Defense Exhibit 351, 352, and 353. Juliana Perez starts her day after the telegram message is already sent, in conflict with what she's told, in conflict with the story that she's adopted on behalf of the Commonwealth. Brendan's at McDonald's. Exhibit 354, 355, 356. Those are time-stamped screenshots from the McDonald's videos. Juliana is on the phone telling us her phone tells us that her activity stops at 7:24 under Defense Exhibit 357. At the exact same time, her watch steps are stopping at 7:24. Defense Exhibit number 358. Defense Exhibit 359, Juliana steps resuming on the phone at 7:41. Exhibit 360, Juliana, car is parked at 7:41. Exhibit 361, Juliana's watch resuming steps at 7:42. We know that Brendan was out of the house. We know that Juliana was in her car. And if you look at Exhibit 362, there's someone who's logging into Christine's laptop at 7:33. There are no other humans in the house. And Juliana and Brendan were not there. In conflict with the government's theory, Christine logs into her laptop and places her devices in a drawer. She puts the devices away. She gets Lily down into the basement, brings her food to the basement, and gates her in. And she meets Joe Ryan. And they walk up to the master bedroom. Why? Why would Joe Ryan stab Christine? If you take away the consensual part of this, if he were found in a bedroom of someone by someone who's a police officer, he'd be looking at a life sentence. In this instance, he was confronted by an armed law enforcement officer saying, "Police." That officer was standing in the only way to get out of that room, other than jumping through the window and falling down 3 flights. He had a gun trained on him, and he was telling him and was told that he was going to be arrested. He had marijuana in his system, and he was angry. Who was he angry at? Could he have been angry at Christine, thinking that she set him up? Could he have been angry at his situation for deciding to go into a house that he didn't know and put himself in this situation? Could he be angry at my client, who was there to try to figure out what was going on and ultimately try to protect his wife? Those are the whys. And if we'd had any investigators that were actually involved in the case coming to the stand, those would be questions that I would want to know, and there would be questions that you would want to know. Because you have a decision before you, and that decision requires a review of all of the evidence. Now, is it reasonable after a 6 to 8 week affair that someone's going to try to get rid of their companion of 19 years, wife of 12 years? Is that reasonable? You heard from my client, he thinks it's absurd. In pursuing this case, the Commonwealth has presented absolutely no forensics evidence that supports that Brendan Banfield had anything to do with this, yet the story continues. This isn't how justice works, and you can't just come up with a theory and make it fit. They're trying to sell you a story without any facts. And we have the facts, and those facts are in evidence. Those jury instructions, when you see them, you'll realize they're very clear. If you have doubts about the investigation, if you have doubts about how they've conducted this investigation, if you believe that there's something that's been held back in this investigation, that's reasonable doubt. That's reasonable doubt before you even get into the things that negate the possibilities of their case. And these are hard decisions. There's a lot on the line. But know this, if they fell short in what you expect should be the investigation, if they fell short, that's not on you. The jury instructions say you must acquit. And it's not on you. I don't have another opportunity to talk to you. It's their burden to prove this beyond a reasonable doubt, so they get the opportunity to speak. So I apologize if I've gone too long, but I wanted to make sure that these important issues came before you. and might leave you with these words. When they lie and manipulate to get someone to make a statement, that's not discovering the truth. That's planting the truth. Ladies and gentlemen, thank you for your attention. Thank you for your patience. And at the end of your deliberations, I ask that you find my client not guilty of all charges. Thank you.
All right. Rebuttal argument. Switch over the mic again, Mr. Carroll.
Thanks. All right, just a couple of last words. Mr. Carroll has a really interesting recollection of the evidence. It certainly doesn't match ours, and I'm guessing it doesn't match yours. FYI, the lab for the coat was 165, not 167. And the DLI lab, it doesn't say anywhere on it that it was touch DNA. It was blood that they tested. Juliana did not repeatedly say that she didn't know how to work Gmail. She said that she did not create the Gmail account, that was Brendan. Giaccio and Bruce had the catfish plan and they peddled it and pushed it to everyone. I don't think that's at all what came out. I think that Mr. Carroll is trying to focus on the HR woes of the Fairfax County Police Department to distract you from the fact that the evidence actually supported that theory and that he has provided you and his client has provided you with absolutely nothing to refute that theory. Why was there so much discussion and disagreement over the digital evidence? Because it could never be that smoking gun. You all heard it from their expert. You can't put someone behind that screen unless you're sitting next to them. So as much as we want it to tell the story here, as much as we want it to be the perfect evidence that proves beyond a reasonable doubt that this thing had to happen, the digital evidence just isn't that. We wish it were, but it's not. And Detective Miller did nothing wrong, and Mr. Lidsky did nothing wrong. They just told you the truth. And the truth is that they can tell you what a device was doing, but they can't tell you who was using the device. Juliana Perez Magalhaes' testimony was bought and paid for. Yes, she pled guilty to a lesser offense in exchange for her testimony. Ms. Frissler made sure you knew that from the get-go. Juliana talked about that. She explained for her reasons why. Nothing was hidden. After her sentence, it sounds like she might have the opportunity to make, what, 10 grand off of selling her story. She said that she would use that to support her family. And then what? Is she gonna work as a nanny? I mean, she's a convicted murderer. Do we really think that it is so reasonable that she made up this complete lie for 10 grand? Really? If this version is correct, coming from Mr. Banfield, then she would be set free. She would be as not guilty as he would be. So she's gonna give up that shot for 10 grand? I just don't buy it. Whose story is more credible here? Juliana's or Mr. Banfield's? Whose version does the rest of the evidence support? The defendant took the stand and he lied. And he lied about collateral matters. He told you that he had a big career-defining work meeting the morning of the murder. And then you heard from his boss who said, no, he didn't. He lied. He said that he and Juliana did not have a plan to kill Christine at the time that they went to the shooting range. Well, he said, not at that time. If he's lying about the things that don't matter, how can you believe a single word he's said? And ladies and gentlemen, you have to do that in this case, because without some alternate theory, the Commonwealth's evidence is uncontroverted. So you got to pick one. Juliana, Mr. Banfield. Whose story does the evidence support? All of that blood, the DNA, to some extent, the digital forensics, the physical evidence collected at the scene. That's what you can rely on. Don't rely on his narrative and his recollection of the evidence. For that reason, don't rely on mine or on Ms. Rissler's. Rely on yours. It is your collective recollection of the evidence that you have heard that is controlling. You know what was said here. You know what the evidence is. We trust you to make the decision. Thank you.
Thank you, ma'am. Members of the jury, this is an important case to both the Commonwealth and the defendant. In order to reach a verdict, each of you must agree on that verdict. In other words, the verdict must be unanimous. The first thing you should do when you get back to the jury room is to select a presiding juror. The role of the presiding juror is to see to it that the deliberations are conducted in an orderly and businesslike manner, that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. It is rarely helpful for jurors upon first entering the jury room to take a straw vote, or for any juror to make an emphatic expression of his or her opinion in the case, or to announce a determination to stand for a certain verdict. To do so before all jurors have had an opportunity to consult with one another and exchange views and opinions might allow your sense of pride to prevent you from retreating from an announced position, even when shown that such position is unsound. You have a duty to consult with one another and to deliberate with the objective of reaching an agreement, if it can be done without offending your individual judgment. Each of you must decide this case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of deliberation, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is an error. However, none of you should surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. In the jury room, you will have the exhibits that were entered into evidence, you will have the instructions of law that I just read to you, and you will have the verdict forms. Much of the evidence in this case was in electronic files, so you're going to have a clean laptop that's going to have those files on there for you, and that you will be able to access, and you also have the big TV in the jury room that you can plug in the laptop to that so everybody can view the evidence at the same time, okay? As far as the firearms and knife, the Sheriff's Department has control of those items. If and when you want to see those items, you just have to let the deputy know, and those items will be brought to you. Only the deputy will handle them, but you can ask her to manipulate them however you wish to have them manipulated. But please do not have any deliberations while the deputy is in the room with you, okay? Wait till the deputy leaves before you do that, okay? All right, so during your deliberations until you are discharged from jury service, you must not communicate with or provide any information to anyone who is not a member of this jury by any means about this case. You may not use any electronic device or media to conduct any independent research about this case, the legal or factual issues in the case, or the individuals or attorneys involved in the case. You are not permitted to consult dictionaries or reference materials, search the internet, visit websites or blogs, or use any other tool to obtain information about this case to help you decide the case. Do not try to find out information from any source outside the testimony and the exhibits received as evidence during the trial. You will have, again, you will also have with you the verdict forms. There's 4 charges in front of you, okay? So you're going to have 4 separate verdict forms, all right? Once you have decided, have made a decision, each of the verdict forms should have the foreperson signature at the appropriate place. There's places for guilty and not guilty for each count that you've heard, 2 aggravated murder counts, 1 firearm count, and 1 child endangerment count, okay? So each form is separately. So each form, upon the finishing of your deliberation, should have the signature of the foreperson just on 1 space on each form, okay? If you sign both places on the form, it gets confused. If we're confused, then that's not the way it works, okay? So just make sure you do that. Okay, now for the last part before you deliberate, the fun part. You remember that in the beginning of this case, I told you we had randomly selected 4 people to be alternates, okay? We still have 4 alternates. Thank you all for your service and being so professional, and even during the snowstorm, making here on time, and we do appreciate that. And let me just say before I release the alternates that I know that this trial has been a huge sacrifice for you all and have taken you away from your lives for for 3 weeks now. I know I speak for all of us associated with this case that I want to thank you for your service in this matter. I know it is hard to have come this far and then not get a chance to deliberate, but that does not lessen the respect and admiration that we have for you. As an alternate, you will not deliberate, but you will still be under the order of the court, okay? And so you cannot do any outside research at this time in the case, or you can't talk to anybody about this case at this time because you're still under oath as a juror. That is because if something happens to a juror during deliberations, I will call you back to service and deliberations would start again as you would be part of the jury as well. So that's why you're still under the order of the court. You are under these restrictions and your oath until a verdict is reached. Once a verdict is reached, we will reach out to you and contact you and let you know this has occurred, and then you are free from all your obligations, okay? So again, thank you for your service. At this time, I'll call the alternate jurors, and if you could go with the deputy, we have to collect your items, and we'll get you on your way, okay? So the alternate jurors I have are number 26, number 24, and number 38. So if you could follow Deputy Johnson out at this time. (26, 17, 24, and 38). 1, 2, 3, 4. Okay, so ladies and gentlemen, these are the 12 jurors that are going to be deliberating in this case, okay? You can take as long as you need to deliberate, and at this point, you can take breaks whenever you wish to, and you can let the court know. If you're still deliberating next week, you can let the court know if you want to come in at 9, you can come in at 9, or if you want to come in at 10, that's fine. When you're done for the evening, I know there's one juror that has to be done by 4:30 today, so make sure we respect that timing for that juror. But you can take breaks whenever you wish. You can take your lunch breaks, and you can make them an hour, you can make them a half hour, you can do what you like. It's just important that you do not deliberate at any time unless all jurors are in that jury room at the same time, okay? So during breaks, we don't deliberate, okay? We make sure we take care of that. All right, do we have another deputy that can? All right, I can excuse you now to deliberate at this time if I have a deputy.
Judge, while we're waiting on that moment, can we approach on one?
Sure, sure. Gentlemen, just one more item before you deliver. If for some reason you have any issues with the laptop, please let the deputy know. And if you're having trouble with any of the exhibits, let us know because we can print out anything and everything that you need, okay? So if it gets frustrating at any point, just let me know and I'll make the parties print anything out that you need, okay? All right, thank you. You can now go to deliberate. If you want to review the verdict forms before they go back as well. The laptop is coming from IT, so if you want to wait for that too for me, so just so you can make sure the laptop is clean and everything, all your exhibits are on there, and then that will go back to the jurors, okay? All right, we'll be in recess then.
All rise.
It's a case of sex, lies, and deadly deception.
Affair murder trial. Live coverage today on Court TV.
Back now to Virginia, where the fate of defendant Brendan Banfield is now in the hands of the jury in the au pair affair murder trial. You can see they've been out for about 6 minutes. This is the case in which the defendant Banfield is accused of killing his wife Christine and another man, Joseph Ryan. The prosecutors say it was all part of a deadly scheme with his lover, who was the family's au pair and who has also already pled guilty to manslaughter. Joining us live from the courthouse in the cold, Court TV legal correspondent Kelly Krapp. Always great to be on with you, Kelly. You've been inside this courtroom, so please tell us what it was like during Banfield's testimony. testimony. And what have you been looking for during today's closing arguments?
Well, good afternoon to you, Judge Ashley. So closing arguments were very interesting to listen to. We just got out from being inside the courtroom, and then also you mentioned Banfield's testimony throughout this week. That was definitely interesting, to say the least. But talking about the closing arguments, which just wrapped up. So this case, just as of a few minutes ago, is now in the hands of the jury. The judge has released the alternates, and so 12 men and women are back there deliberating this case. I can tell you from being inside, listening to the closing arguments, I just want to talk with you about inside the courtroom. So it is packed on both sides, Christine Banfield's side as well as the defendant's side. A lot of media professionals are in there as well, some lawyers, family members of Christine, her mother and father, listening to these closing arguments. And I watch the jury as closing arguments are taking place. So the prosecutor is very concise in her delivery and in her arguments, very factual, going down element after element that they have to find in this case in order to find him guilty, especially of that top charge, those top charges. Now, when defense counsel was going and giving his closing remarks, I can tell you that there are 4 people that were in the back row, one of whom is about the age of the au pair, very similar in age, at least she looks that way. And as she is listening to the closing argument from defense counsel, she has her sleeve over her hand and just resting her chin on her head and really listening to him closely as he's describing Juliana coming over from Brazil, taking this plea deal, and telling what the defense counsel is saying is a bunch of lies in order to meet the Commonwealth's theory here. 3 gentlemen next to her also were in that same position as defense counsel was giving his closing arguments, because this was the first time that really, I can tell you that it really piqued a lot of their interest when defense counsel was talking about the why. And I'm not sure if we've gotten there yet on court TV with him talking about the why and the closing arguments, but I can tell you this piqued a lot of people's interest because he was describing, well, why would Joseph Ryan want to stab Christine in the first place? And then he talked about being confronted by a police officer, being possibly mad that Christine Banfield would have set him up. And I can tell you at that point that seemed to resonate with some of the jurors that were sitting there, Judge Ashley. So really interesting to hear the closing arguments and the different perspectives here in this case. Defense counsel attacking that catfishing theory, talking about the fact that there are a lot of holes in the prosecution's case in regard to the transfers out of the Fairfax County Police Department in regard to the investigation of this case. But the prosecutor really talking about the blood evidence and saying the blood evidence is what you can find Brendan Banfield guilty on.
Oh, gosh. Now, I have 2 questions for you, Kelly. The first is, please remind us, in this courtroom in the Commonwealth, were the jurors allowed to take notes during testimony or not? Every court's a little different.
Yes, they were allowed to take notes, and some of them, as we always see in a lot of these cases, take more notes than others. Throughout, I can tell you, even with the closings that are taking place, a lot of the jurors are looking down, just taking like a review of the things that they have in front of them. Defense counsel's asking them to look at a lot of exhibits in this case. So a lot of note-taking throughout, especially Brendan Banfield when he was doing his testifying. And I noticed one gentleman in particular, when Brendan Banfield was on the stand, it was as if he was writing things down and then going back and seeing if they all added up. At least that was my perception of him.
All right, and the second question I had, did the court give any guidance as to how long everyone has to get back to the courtroom if and when there's a question or a verdict in this case?
No, I was listening for that, but she runs a tight ship. So if there's a question or if there's a verdict, you better just hurry back there. She did give the guidance as to the jurors, as to, of course, they can deliberate as long as they want, take as many breaks as they want, take a half hour for lunch, take an hour for lunch. And then she mentioned even into next week, because we have that hard out today of 4:30. One juror in particular has to be gone by 4:30 today. So if they do not have a verdict by that time, we will end up coming back next week.
All right, Kelly Craft, thank you so much for your excellent reporting. We stand by to hear more when anything comes from the jury deliberation room. Right now, still with us, criminal defense attorney Joseph Tully. Joseph, one of the things that I pulled out of the defense closing argument was when he said that this catfishing theory doesn't make any sense unless the au pair had adopted the theory of the case that the Commonwealth was putting forward as a story. So my question is, do you think at the end of the day this really boils down to whether or not a jury believes the au pair in her testimony or the defendant in his testimony? Is it that simple, so to speak, of a case?
You know, I think the circumstantial evidence actually outweighs anything that anybody could say. I think just looking at the evidence, not really paying attention to any of the witness statements, the jury could easily get a guilty verdict here, just in terms of what happened. As I'm analyzing this case, I'm taking the 30,000 foot view, and I'm seeing it being a very good case for the prosecution. And then when I analyze every last little detail, I see it being good for the prosecution. I think in between, the defense has some arguments, but they're not very good ones.
I agree with you. I think the defense did the best that they could with what they had. I do have to ask you one other quick question before we go back to court, and that is, did it surprise you that Brendan took the stand, Brendan Banfield, in this case?
It did. It did surprise me. But I think it was just a Hail Mary. I think they had a bad case. They knew it, and it was just a Hail Mary.
Yeah, I was a little surprised as well. All right, stand by if you would. Please, sir, we're going to go back into court for more of the defense's closing argument.
Ladies and gentlemen, we left off in the discussion of the bloodstain pattern analysis. And what was an interesting moment in terms of the experts was when there was talk of bloodstain inside the zipper and around that area. But if you look at the DLI report, which is number 169, you'll see in that report they were looking actually for touch DNA. They weren't actually looking for blood staining. They identified blood staining, but the whole point of it was to find Brendan Banfield's touch DNA on the inside of Joe's pants based upon some theory that he was either pulling the pants off or moving them or something like that. And that was one of the reasons why they went to a private lab to try to do that, and it didn't pan out. And you'll see the report. Now, in terms of the evidence on the bloodstain pattern analysis, let me just do a rundown. With regard to the knife, it was identified as being bloodstained. Leanne Singley said that. She negated the possibility of anything being wiped off, which might be one of the things that you might find in a situation of the nature of the government's theory, but she's negated that. That it contained DNA of Christine and Ryan, and Brendan was excluded. That Joe Ryan's DNA at the base of the blade, handle juncture, that was the testimony of Leanne Singley and also confirmed by the Division of Forensic Science. That Ryan had a puncture to the left thumb, that was Leanne Singley's testimony, as well as the medical examiner, Dr. Kessler, confirmed that. It was consistent with the knife, Dr. Kessler said, and it was consistent with the self-wounding that happens in situations involving stabbings. And you heard Leanne Singley touch on that, and she was able to kind of give you a more circumspect view of what self-wounding was. I think Ms. Groff talked about slicing, fingers or it's sliding or something like that. What we were looking for, and what I think Leanne Singley was able to tell you, is that there are a wide variety of injuries that occur, but oftentimes the stabber is someone that's injured. And I think there were significant statistics that she talked about, which I won't try. You'll have to rely on your recollections regarding that. You saw on the body cam footage, as well as through Ms. Singley's testimony, that Brendan does not have any injuries on his hands. And Ms. Dolly's testimony indicates Ryan's right hand closed when blood was deposited on it. That's consistent with Ryan holding the knife when stabbing, causing blood stains. Joe Ryan, there's a lot to be said, and I think you've already seen pictures of it in this closing, of the 4 stains on Ryan's forearm. What hasn't been said is that they were not tested. Leanne Singley says they're not able to be classified. Ms. Groff disagrees, saying that they are drip stains. She needs to say they're drip stains, which Leanne Singley says you can't say because you don't know the position of the arm, you don't know where it was at the time the blood came out. It could have been something from a significant bleeder as he's standing up. It could have been from numerous other possibilities. But Ms. Groff classifies something that Ms. Singley says you can't classify without certain factors, suggesting that it's falling from above and has Ryan on the floor.
Again, pausing it there so you don't miss a thing. 18 minutes is how long this jury has now been out deliberating. So coming up next, right after the break, don't go anywhere. More of the defense's closing argument in the Au Pair Affair murder trial. We'll be right back. Welcome back to Court TV Live. I'm Judge Ashley Wilcott in today for Ted Rowlands. Let's turn now back to Virginia, where the fate of Brendan Banfield is in the hands of a jury. Prosecutors say that Banfield was the mastermind in a disturbing plot to lure an unsuspecting man to have violent sex with his wife and then frame him for her murder. The family au pair, who was just 21 years old at the time, testified about the affair and her role in the murder plot. But the defense says that the prosecutors took advantage of the young nanny and pressured her to change her story. Let's go back into court together now for more of the defense's closing argument.
One might think you'd find the source of whatever that blood is if you're to have tested the blood that's in question. That might give you a little more guidance. And I think that's one of the reasons Leanne Singley was unable to identify that. If it was from Joe, then she'd probably have some explanation for that as an expert. If it was from anyone else, that perhaps could be a different explanation. But now all we deal with are possibilities. And that seems to be the crux of how the Commonwealth is pursuing this case. They're not putting on any evidence in terms of their own investigators. They're not providing any concrete evidence as to what happened that day. And interestingly enough, the shift in the last closing argument was that I hadn't been doing that. And the defense hadn't been doing that. But I think we can all agree that we've called significantly greater number of police witnesses because we had to. Because we want the truth out here. I called my client, though he has the absolute right not to come up and testify. And he testified. And the relationship issues with Juliana Perez Magalhaes are touchy, and they're an awful story. But he sat there and he answered the questions. He was cross-examined. He answered those questions. We're bringing you the truth. We're trying in every way to get the truth. And many of the Fairfax County detectives have provided that, and that goes to their integrity. The genes, the touch DNA from the waistband zipper indicate Joe Ryan and Christine Banfield are the contributors. Brendan Banfield is excluded. All samples collected and tested on Ryan were from Joe Ryan or Christine. Brendan not identified as a contributor in any of them. Nothing in the materials reviewed gave any indication that Ryan was not the stabber. That was Leanne Singley's testimony. Brendan's jacket, blood on the rear of the right sleeve, DNA on exterior of right sleeve, mix of Ryan and Christine. Brendan indicates that Ryan grabbed his arm on Officer Beckner's video, Officer Baumler's video, in the ambulance, and also in the hospital. Brendan's jeans, the small stains on the thigh is consistent with cast off from the hands. That's Miss Dolly, Miss Groff. Brendan sat in the bathroom, if you look on the video, and the first responders arrived. He was basically told to sit on the tub, and you see him when you look at that video, and he's sitting there, and he's just, hands down, not sure where his hands go, and he was watching as his wife was being tended to. The stains on Brendan's jeans are consistent with him kneeling at Christine giving aid. That's what the body cam video shows. Back to the digital forensics for a moment. February 19th was a critical day because that was the beginning of the Telegram account. Juliana says she watched Brendan. They stole the laptop and the phone. They deleted the two-factor authentication code, but the two-factor authentication code remains on the phone to this day. And this is Defense Exhibit 156. Is it possible that Brendan and Juliana did this without Christine knowing that a Telegram account was opened in her name? It's not, based upon this exhibit. Because if you look at it, and you can look at the message from Telegram, shows up right underneath a message from Brad of Inova PICU, and right above a message from Nicole at Inova PICU. It was done early in the morning. If it had been done by someone other than herself, as soon as she looks at that message from Nicole, she'd realize something's going on. I should check this out. Inconsistent with catfishing and consistent with someone pursuing a fantasy. February 23rd, we saw digital forensics evidence from the evening of February 23rd. We saw use of Christine's laptop for 90 minutes for resort searches, with a couple of minutes of Telegram use interspersed. The Commonwealth in cross-examination opined, well, wouldn't it be possible that even if you were sitting in the same room, that she could have gone away to go to the bathroom for 2 minutes? And I guess, you know, in this world, anything's possible. Is it probable, however? And that's really the more germane point to this. The Commonwealth's, I guess, concern in cross-examination was confirmed, at least in terms of the room, when Brendan testified. And if you recall his discussion, we were talking about, we were already going on a cruise and we were talking about going to the Dominican Republic. We saw the calendar that showed the place, Royalton Resorts. We showed the searches that showed kid-friendly vacations. So we knew who was behind the keyboard, and Brendan knew who was behind the keyboard because he was there with Christine. And they were collaborating on the vacation research. Brendan was playing with Valerie and Christine was on the couch with her laptop and her phone. That's the testimony. The device's symmetry and connectivity you heard about has the context to complete the entire picture. Juliana was not in the room, and this is supported by the analysis on her phone, showing a steady stream of messaging, social media use, and Netflix at the same time that Telegram, FetLife, and the suspect Gmail account were being used by Christine. And finally, February 24th, Juliana was not awake and not out of bed based on her devices at the time she claimed to be watching Brendan Banfield sending messages in the kitchen. You heard Mr. Litsky talk about her Apple Watch. You heard him talk about her phone. We're showing when steps were showing, which would be an indication of someone moving. She had not moved for some time after the laptop was accessed. What we know from the testimony yesterday was that Christine Banfield had the laptop and the phone in her bedroom and was awake when he went up to retrieve Valerie. That is an artifact in the world of digital forensic analysis. And you'll see this entire exchange, Defense Exhibit 348, 349, 350. You'll see Juliana Perez Magalhaes' first steps at 626, Defense Exhibit 351, 352, and 353. Juliana Perez starts her day after the telegram message is already sent, in conflict with what she's told, in conflict with the story that she's adopted on behalf of the Commonwealth. Brendan's at McDonald's. Exhibit 354, 355, 356. Those are time-stamped screenshots from the McDonald's videos. Juliana is on the phone telling us her phone tells us that her activity stops at 7:24 under Defense Exhibit 357. At the exact same time, her watch steps are stopping at 7:24. Defense Exhibit number 358. Defense Exhibit 359, Juliana steps resuming on the phone at 7:41. Exhibit 360, Juliana, car is parked at 7:41.
All right, we need to take one of those breaks, but I need you to notice if you see the clock's been paused. That's because the jury went to lunch after 18 minutes of deliberating. Of course, when they come back and begin again, the clock will start again. Also, coming up next, we'll have the remainder of the defense's closing argument. Go on social media. What do you think of the defense's closing argument? Stay tuned. We'll be right back.
An affair with the family's au pair lead to double murder.
I'm gonna kill her, I'm gonna kill her.
It's a case of sex, lies, and deadly deception.
The Au Pair Affair murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest verdict watch updates.
Closing Arguments with Vinnie Politan. Tonight at 8, 7 Central. Only on Court TV.
believe that it was overwhelming that this was a catfish. I think the term has been used kind of across the board now. That was set up by the defendant, yes.
Was one of those theories catfishing?
It wasn't stated what the theory was. It just said there were two theories and you need to get behind the right one.
Do you know what catfishing is?
Yes, sir.
Okay. Was that something that you were pushing with your homicide detectives at any point?
I wouldn't characterize that as pushing.
The case against Brendan Banfield is now in the hands of the jury. They are currently at lunch. That's why the clock has stopped, but they'll resume deliberations in about 15 minutes. The big question for this jury is who was behind the FetLife account that would eventually become the center of a double murder investigation. The Commonwealth says that Banfield and his au pair turned mistress created the account in his wife's name to lure and frame another man for her death. But the defense says that Christine was behind that account and claim several detectives came to the same conclusion during the course of their investigation. We want to go back into court together now for the rest of the defense's closing argument.
Exhibit 361, Juliana's watch, resuming steps at 7:42. We know that Brendan was out of the house. We know that Juliana was in her car. And if you look at Exhibit 362, there's someone who's logging into Christine's laptop at 7:33. There are no other humans in the house. And Juliana and Brendan were not there. In conflict with the government's theory, Christine logs into her laptop and places her devices in a drawer. She puts the devices away. She gets Lily down into the basement, brings her food to the basement, and gates her in. And she meets Joe Ryan. And they walk up to the master bedroom. Why? Why would Joe Ryan stab Christine? If you take away the consensual part of this, if he were found in a bedroom of someone by someone who's a police officer, he'd be looking at a life sentence. In this instance, he was confronted by an armed law enforcement officer saying, "Police." That officer was standing in the only way to get out of that room, other than jumping through the window and falling down 3 flights. He had a gun trained on him, and he was telling him and was told that he was going to be arrested. He had marijuana in his system, and he was angry. Who was he angry at? Could he have been angry at Christine, thinking that she set him up? Could he have been angry at his situation for deciding to go into a house that he didn't know and put himself in this situation? Could he be angry at my client, who was there to try to figure out what was going on and ultimately try to protect his wife? Those are the whys. And if we'd had any investigators that were actually involved in the case coming to the stand, those would be questions that I would want to know, and they would be questions that you would want to know. Because you have a decision before you, And that decision requires a review of all of the evidence. Now, is it reasonable after a 6 to 8 week affair that someone's going to try to get rid of their companion of 19 years, wife of 12 years? Is that reasonable? You heard from my client, he thinks it's absurd. In pursuing this case, the Commonwealth has presented absolutely no forensics evidence that supports that Brendan Banfield had anything to do with this. Yet the story continues. This isn't how justice works. And you can't just come up with a theory and make it fit. They're trying to sell you a story without any facts. And we have the facts, and those facts are in evidence. Those jury instructions, when you see them, you'll realize they're very clear. If you have doubts about the investigation, if you have doubts about how they've conducted this investigation, if you believe that there's something that's been held back in this investigation, that's reasonable doubt. That's reasonable doubt before you even get into the things that negate the possibilities of their case. And these are hard decisions. There's a lot on the line. But know this, if they fell short in what you expect should be the investigation, if they fell short, that's not on you. The jury instructions say you must acquit. And it's not on you. I don't have another opportunity to talk to you. It's their burden to prove this beyond a reasonable doubt, so they get the opportunity to speak. So I apologize if I've gone too long, but I wanted to make sure that these important issues came before you. And might leave you with these words. When they lie and manipulate to get someone to make a statement, that's not discovering the truth. That's planting the truth. Ladies and gentlemen, thank you for your attention. Thank you for your patience. And at the end of your deliberations, I ask that you find my client not guilty of all charges. Thank you.
All right. Rebuttal argument. That concludes the defense's closing argument. Let's bring in our guests for this hour to discuss. Joining us now from Los Angeles, California, trial attorney Philip Dubé. Philip, always great to be on with you. Thank you for joining. I have to share this with you. Court TV did a poll, and 92% of those who took the poll said that they think he will be found guilty. But a viewer who watches all the time tweeted this and said, when the defense brought up that the Commonwealth only had possibilities, I thought that's the epitome of reasonable doubt. I think he walks. Where do you fall? Guilty or not guilty? And what are your thoughts?
Yeah, and the defense only needs that one holdout. I mean, that's the whole point. I think it's great. If you have one person who has a doubt, a reasonable one, then he doesn't walk. It means they get a retrial on it. And you never know what the next 12 may or may not do or if the case settles. But that is the whole point of a defense closing argument. I got to tell you, Judge Ashley, from where I'm sitting, I couldn't tell if I was at a closing argument or a eulogy. I mean, this defense attorney absolutely had no energy. It was one of the most flaccid closings I've ever seen in my career. I mean, there is a fine line between advocacy and sleepwalking, so he really has to step it up. I'm not kidding. He took his glasses on and off more times during that closing than you would see somebody do frame shopping at a lens crafters. You could not even focus on what he was saying. So a lot of it has to do with the demeanor of counsel during their closing. But having said that, he did touch upon 2 points. And in the final analysis, all that really matters is whether or not the jury believes Juliana. If they believe her, it doesn't really matter what Brendan had to say. It doesn't even really matter what defense counsel has to say. She will save the day for the state.
All right, so that's where I wanted to go is what do you think they're going to rely on if they in fact come up with a conviction of this defendant? But I want to talk a little bit more about the demeanor of defense counsel because a lot of viewers weighed in and the judge was frustrated because defense counsel in presenting evidence, documents, exhibits really didn't appear to be very well prepared and was causing delays and taking too long and trying to figure it out. And all of these things, does it affect the jury? Do they hold any of that? And I too find the closing argument not to be compelling to watch, right? And the demeanor that he had. And so are those things ever used by a jury against a defendant?
Of course they are. I mean, normally looks are currency. When you have a grizzled, seemingly experienced attorney in front of a jury, it looks like they've been doing this for many years and they know exactly what they're doing. But in the final analysis, the proof is in the pudding. He was stumbling. He had multiple papers in his hands. He kept taking his glasses on and off, looking down at his notes. Honestly, I couldn't believe what he was doing, and the jury cannot concentrate or focus. So what happens when all that is going on? They actually take it out on a defendant because rather than focusing on whether or not there's doubt, they're focusing really on the weaknesses of defense counsel. And that should never, ever, ever be the starting point during deliberations. It should be focusing on the strengths and the weaknesses of the evidence.
Yeah, it's going to be interesting to see what this jury decides. They are still at lunch right now. Philip, we're going to take a break. When we come back, the state rebuttal closing. The state always gets the last word. We're going to hear what they have to say. Welcome back to Court TV Live. I'm Judge Ashley Wilcott in today for Ted Rollins. Let's get you back to Virginia, where we've been watching closing arguments unfold in the au pair affair murder trial. Prosecutors say that the defendant, Brendan Banfield, killed his wife, Christine, and another man, Joseph Ryan, in a plan to run off with his mistress, who was also the family's au pair. But the defendant took the stand this week to refute that claim, telling the jury that he played no part in the catfishing murder plan. Let's go back into court. The jury's at lunch. We're bringing you the remainder of these arguments right now. This is the Commonwealth's rebuttal closing.
Just a couple of last words. Mr. Carroll has a really interesting recollection of the evidence. It certainly doesn't match ours, and I'm guessing it doesn't match yours. FYI, the lab for the coat was 165, not 167. And the DLI lab, it doesn't say anywhere on it that it was touch DNA. It was blood that they tested. Juliana did not repeatedly say that she didn't know how to work Gmail. She said that she did not create the Gmail account, that was Brendan. Giaccio and Bruce had the catfish plan and they peddled it and pushed it to everyone. I don't think that's at all what came out. I think that Mr. Carroll is trying to focus on the HR woes of the Fairfax County Police Department to distract you from the fact that the evidence actually supported that theory and that he has provided you, and his client has provided you with absolutely nothing to refute that theory. Why was there so much discussion and disagreement over the digital evidence? Because it could never be that smoking gun. You all heard it from their expert. You can't put someone behind that screen unless you're sitting next to them. So as much as we want it to tell the story here, as much as we want it to be the perfect evidence that proves beyond a reasonable doubt that this thing had to happen, the digital evidence just isn't that. We wish it were, but it's not. And Detective Miller did nothing wrong, and Mr. Lidsky did nothing wrong. They just told you the truth. And the truth is that they can tell you what a device was doing, but they can't tell you who was using the device. Juliana Perez Magalhaes' testimony was bought and paid for. Yes, she pled guilty to a lesser offense in exchange for her testimony. Ms. Bristler made sure you knew that from the get-go. Juliana talked about that. She explained for her reasons why. Nothing was hidden. After her sentence, it sounds like she might have the opportunity to make, what, 10 grand off of selling her story. She said that she would use that to support her family. And then what? Is she gonna work as a nanny? I mean, she's a convicted murderer. Do we really think that it is so reasonable that she made up this complete lie for 10 grand? Really? If this version is correct, coming from Mr. Banfield, then she would be set free. She would be as not guilty as he would be. So she's gonna give up that shot for 10 grand? I just don't buy it. Whose story is more credible here? Juliana's or Mr. Banfield's? Whose version does the rest of the evidence support? The defendant took the stand and he lied. And he lied about collateral matters. He told you that he had a big career-defining work meeting the morning of the murder. And then you heard from his boss who said, no, he didn't. He lied. He said that he and Juliana did not have a plan to kill Christine at the time that they went to the shooting range. Well, he said, not at that time. If he's lying about the things that don't matter, how can you believe a single word he said? And ladies and gentlemen, you have to do that in this case, because without some alternate theory, the Commonwealth's evidence is uncontroverted. So you gotta pick one. Juliana, Mr. Banfield. Whose story does the evidence support? All of that blood, the DNA, to some extent, the digital forensics. the physical evidence collected at the scene. That's what you can rely on. Don't rely on his narrative and his recollection of the evidence. For that reason, don't rely on mine or on Ms. Frissler's. Rely on yours. It is your collective recollection of the evidence that you have heard that is controlling. You know what was said here. You know what the evidence is. We trust you to make the decision. Thank you.
Thank you, ma'am. Members of the jury, this is an important case.
All right, still with us, trial attorney Philip Debate. Philip, from my perspective, that was a textbook rebuttal argument because she went specifically through things that defense had said in closing and said, that's wrong. Here's why it's wrong. Here's why the state gave you a case to convict him beyond a reasonable doubt. But share your thoughts, please, sir.
Well, first of all, she is correct. What is there to believe about the defendant? He obviously has the most to gain in the case. But let's go with that. What if you have many aspects of Juliana's testimony that you don't believe? And obviously, she is the one who's got the sweetened pot because she's getting the time-served deal with a one-way slow boat back to Brazil. She's going to be out of here and escape a life in prison. And Lord knows who wouldn't rather be free in South America than incarcerated in North America. So she has every incentive to lie. The point is, if all you have is lies from him and lies from her, to many jurors, that could be reasonable doubt. But if we're all honest, Ashley, jurors also check their common sense or don't check their common sense at the door. So when they come into that jury room and they don't know who to believe, they look at the evidence. Well, what do you have? You have a dead wife and you have a dead straw man. Something had to have happened to stage or otherwise synchronize or orchestrate that. And what would be Juliana's incentive? So she can be with a former IRS law enforcement agent who maybe makes $100 grand a year? Really? Is that really the sugar baby she wants to be to him? It's doubtful. I think when you use common sense, he's going down.
I don't know. A lot of viewers have commented that they believe Juliana did start it, did start the coming on to the defendant, starting that affair, and that perhaps, yes, that's her motive. She wanted him to take care of her. But saying that, I'd like you to comment on Juliana Magalhaes when she testified. Did you find her credible? Because I will say this, between direct and cross, she told the same facts. I didn't find that any of her factual allegations really changed, meaning that adds to credibility in my mind.
I did believe her on a personal level. I did. And yes, she did have an incentive to lie, and that's what you bring out on cross or even on direct, that she was getting a plea deal to avoid a life behind bars. But I did not really see any inconsistency or falsity, if you will, that was so material or so intentional to say that she's trying to hoodwink the jury. I mean, she basically said that he killed Joseph and killed Christina. That was her testimony. And if you really think about it, he told 911 that he shot Mr. Ryan. So right there, you've got him admitting one count of murder. The real question is, do you buy his reason? And in order for you to believe his version of events, you'd have to believe that he was going up those stairs, like going through that fatal funnel, like James Bond 007, because he really believes that his wife is in distress. The whole thing seems too concocted to be believable.
Yeah, I don't disagree with you, Philip. Of course, we don't know what that jury's going to do. They're still at lunch. Stand by, please. Coming up, we are going to take a look back at Banfield's time on the stand as we wait for the verdict. As soon as they come back from lunch anytime, the clock will start again. But we want to listen to what he says happened the morning that his wife was murdered.
Tragic murder of Keith Canero and his entire family.
This one is the most brutal case that I've seen in my experience here.
The Mansion Murders Trial. Live coverage today on Court TV.
Tonight on closing arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest verdict watch updates.
Closing arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
Back to Virginia now, where the fate of defendant Brendan Banfield is in the hands of the jury. Prosecutors accused Banfield of conspiring with his nanny to kill his wife, Christine, in an elaborate plot to frame a man that he allegedly found on a fetish dating website. As we wait for the jury to come up with a verdict, let's take a closer look back at some highlights from Banfield's time on the witness stand. Take a listen as he tells the jury his side of the story of his confrontation with Joseph Ryan.
I was very fearful of hitting Christine.
And so what if anything, when the time came, well, were you considering using your firearm?
Yes.
At what point did that start?
I mean, very quickly in the situation, but there's only, his head isn't far from Christine's head. I guess his part of his body is partially behind Christine's body. Part of his body is behind the bed. It's a very tight situation.
Okay. And so you delayed from your first instinct?
Judge, objection is to leading.
What, if anything, did you do then?
I'll sustain the objection.
I mean, I know that I told him to let her go at least one more time, and then I know that I told him that he was going to be under arrest.
Okay.
I missed that. At some point, he asked for me to leave, and at a different point, he asked for himself to leave.
And what did you say to those requests?
At that point, that was when I told him that he was under arrest.
Okay. Can you explain to the ladies and gentlemen of the jury what, if anything, took place that caused you to discharge your firearm?
It appeared that he did a very forceful stab towards Christine, and Christine kind of spun away from him. So she was facing towards me, and I guess she rotated as she spun away from him and landed on her stomach on the ground. This kind of had Joe now on his knees, kind of facing Christine, of which I saw him do a downward stabbing stroke, and that's when I fired at him.
And when you fired, were you able to determine whether or not you made contact?
I didn't know where I made contact, but I believed that I made contact as he moved.
Okay.
He moved backwards, He moved backwards a little bit away from Christine. At that point.
And what did you do?
I immediately hurried towards Christine, and I actually stepped over her, and I told her to stay down as I stepped over her. I did this so that I could look at Joe Ryan and see if he was still a threat.
And what, if anything, did you see when you went over there?
I saw the knife on the floor.
Okay. Was that the first time you saw the knife in its full?
That was the first time I could fully see the knife. The other times, it was in his grip, and obscured by Christine's hair.
And the knife that you saw is the same knife that you've seen in the Commonwealth's photos?
Yes.
Okay. Before, at some point, did you help Christine?
At that moment, I did not help Christine yet. I used my foot and dragged the knife towards me with my toe to move the knife away from Joe.
Okay, so if you can, so that there's an image in their minds, can you explain from stepping over Christine to doing what you just said with the knife?
I probably need to take another step or two to get closer to Joe. The knife was...
Still with us, trial attorney Philip Dubé. Philip, I just had a hard time believing in the level of details that the defendant provided, and also he's so dispassionate. Now, granted, he was an IRS agent, so perhaps those personalities go hand in hand, but do you find him at all credible?
No, not in the least, to be honest with you. Listen, if Lord forbid, Ashley, you or I ever need to call the cops, we don't call 911 and give our name, rank, and serial number. You don't call and say, yeah, hi, this is Judge Ashley, duly appointed by the governor, sworn to uphold the laws of Georgia and the United States Constitution. And while I got you on the line, I had to shoot someone. It is just ridiculous. It's almost as if he's trying to parade his credentials around to camouflage the guilt behind it all. So, no, I don't think that's going to sit well with this jury. And you know what else nobody has talked about throughout this trial, Ashley? Nobody talks about Mr. Ryan. Imagine that man's shock, his fear and dismay that he is a sort of quirky, fetishistic, lonely heart looking for some action, getting lured into this coordinated hit. It'll be interesting to see if and when Mr. Banfield is convicted, who comes to court on his behalf for victim impact. Honestly, I'm sure he has touched many lives. I'm sure there are a lot of people out there who really care about him. And yes, he's got this unconventional, quirky kink, but he certainly did not deserve capital punishment.
I know. My team and I were talking about the fact we haven't heard much about him. He allegedly lived with his grandmother. We'll stay tuned for that if there is a conviction. Stay tuned. Thank you, Philip Dubé. We're going to continue on a verdict watch in Virginia for the Au Pair Affair murder trial.
Change your dress. I'm moving out.
Why did you shoot General Ryan on February 24th?
He was attacking Christine. Christine told me that she was bleeding out and that she was sorry and that she loved me.
You agree you're on video holding her neck with your bare hand, correct?
I think so.
So where had the towel, the blanket, the sheet gone at that point?
Welcome back to Court TV Live. I'm Ashley Wilcott, honored to be with...
Yes, I'm Michael Ayala, folks. And of course, as always, we're giving you your front row seat to justice. We are on verdict watch in the au pair affair murder trial for Brendan Banfield. The jury has been deliberating now for 46 minutes or so.
All right. The prosecutor said that Brendan, in closing arguments, that Brendan plotted with the family's au pair to come up with an elaborate plan to kill his wife, Christine, and another man, Joseph Ryan.
Banfield admitted on the stand that he did shoot Ryan, but says it was because he found the man stabbing his wife in their bedroom. Now, in the defense's closing argument, Banfield's attorney says the au pair, Juliana Magalhaes, is the one who actually came up with the plot.
It is now up to this jury to decide which version of the events they believe. Joining us now from outside that courtroom in the very cold is Court TV legal correspondent Kelly Craft. Kelly, always great to see you. Thank you for being on with both of us. Tell us, what was it like inside that courtroom during Banfield's testimony this week?
Well, hi there, Judge Ashley and Michael. Well, during Banfield's testimony, it was quite interesting, to say the least, when he testified. But I do want to talk about the closing arguments that took place just today, because that was another interesting thing inside this courtroom, because it was packed, busier than we have ever seen it. Even for Brendan Banfield's testimony, when he was on the stand, it was busy inside that courtroom, but not as packed as today, where you had family members from Christine Banfield, as well as on the other side, you had family members from the defendant in this case, Brendan Banfield, as well. The jurors paying close attention to those closing arguments. Two of the gentlemen throughout this case, we have noticed, have kept their hands, their arms crossed in front of their chest. Same demeanor from those two gentlemen today. Some people in the back room definitely leaning in the back row of the jury box, leaning in when defense counsel was delivering his closing argument. Another gentleman I noticed just kind of looking down a lot, as if he was reviewing some of his notes, but definitely piqued their interest when defense counsel was talking about his client and no DNA from his client being on the knife, and then also explaining the why as to why Joseph Ryan would have stabbed Christine, because he says the person who brought the knife, Joseph Ryan, that kitchen knife, to the scene is the one who stabbed Christine Banfield. Michael, Judge Ashley.
Kelly, what else stood out to you from the closing arguments? I know there was a rebuttal argument put on by the state, also a rebuttal case, but as well as their closing argument. Tell us what stood out to you about that.
So, Michael, the delivery is very different between the prosecutor and defense counsel. The prosecutor is very concise, going down the elements, really laying out that prima facie case, the prima facie case, to establish aggravated murder, because she's wanting that top charge. So defense counsel and Brendan Banfield, they were talking about this idea of defense of others, that Brendan Banfield, when he was on the stand, he said that he acted in defense of his wife. That's why he ended up shooting Joseph Ryan. The prosecutor is saying that's not true, and she talked about the comparison between the testimony between Juliana as well as Brendan, saying one of them is lying, and she says it's Brendan Banfield. Let's go ahead and listen to some highlights.
The blood evidence. You heard from Lieutenant Giacchio and former Deputy Chief Bruce that it was Iris Dalligraph's report that finally pushed this case over the edge and brought the charges against Mr. Banfield months before Juliana decided to flip. That's how strong this evidence is. That's how reliable this evidence is. Ms. Dalligraph walked us through so many inconsistencies in this scene. proving that it had been manipulated. And you heard absolutely nothing from the defense about this evidence. Mr. Banfield gave you zero explanation for any of this evidence.
Juliana made it up. She told the Commonwealth what they wanted to hear, and without question, they just took it as their story. She told this lie to secure herself a deal that benefited her. This one event relating to digital forensics is reasonable doubt, because every other event going forward requires Brendan, based upon her statement that she didn't have anything to do it, she didn't know how to do the Gmail account, she didn't know anything about the setup, requires Brendan to be involved, or Christine.
Michael and Judge Ashley, I can tell you during that rebuttal close, the prosecutor addressed what defense counsel was saying there in regard to Juliana, and she was questioning, well, what'd she make it up for? Why? For $10,000? This is talking about how defense counsel was addressing her offers from Hulu and Netflix to get kind of a TV deal or a made-for-TV movie if she provided information about what took place, her affair with Brendan Banfield, as well as her childhood. So the prosecutor was saying that in close, what'd she do it for $10,000? I think there was a part there, and it was really hammered by defense, is, well, basically what she was doing is wanting her freedom. So I think some jurors were a little bit questioning that one part of the prosecutor's statement just in her close, that argument. You could tell that kind of piqued their interest a bit because, well, really, she wouldn't have done it for $10,000. She did it for her freedom. If you want to believe what defense counsel is saying, which is Juliana Magalhaes is lying.
Yeah, fair enough. All right, Kelly, thank you so much for that report, getting out from the cold. Folks, again, we're still on verdict watch there. They've been deliberating now about 52 minutes or so right now. Let's welcome in our guest with us, trial attorney Mackenzie Joy Brennan. Mackenzie, great to see you. Thank you so much for joining us here on the program. And I want to address what Kelly was just talking about, this idea as to why Juliana Magalhaes would lie. For me, that is one of the strongest parts of the defense's case. I think there's a pretty good reason why she would lie. And I think that freedom, the fact that she was struggling with being in prison, she's in another country, she was corresponding with both the defendant and her family, wanting to get out of there. She was talking about depression. It makes sense to me that that's something she would do. So I don't know if that's really a great area for the prosecution.
Yeah, I think it can go both ways. I think the challenge is that somebody in her position who is telling the truth would also do all the things that the defense is describing as being questionable. So to me, it's not really decisive either way. I think the money is going to be a big piece for the jury because juries love decisive pieces of evidence like that. And I'm wondering if there are son of Sam laws in Virginia that might impact how much she can profit off of something like this, because that's surprising to me that she potentially could profit at all. A lot of states do prohibit that, and I could have seen that as being part of the terms of her plea, that she not participate in something like that, because it does harm the prosecution's case. So that's interesting. I don't know personally whether I think that it affects the image of her credibility, because the bottom line is she was an incredibly vulnerable person in terms of the power dynamic here. And she also did not take the easier plea early on. So this really is not the best case scenario for her. And if she were looking for the simple best case scenario, it seems like there were other off ramps that she actively declined to take. And this is not a super great one for her. You know, she's not going to have a good life after this. It will be hard to get a career. She tried to come to this country. That's not going to pan out. It's not a great outcome for her. So I don't know how compelling that is in the end.
All right, not a great outcome for her. I need to talk about what stood out to me was a specific piece of the defendant's testimony when he testified, and a reason why I question any of his story. Let's listen to that together.
Christine told me that she was bleeding out and that she was sorry and that she loved me.
And she's chatting with you with these wounds in her neck, correct?
Yes, her voice is very hoarse. She was having difficulty speaking, but yes, she was talking to me.
All right, Mackenzie Joy Brennan still with us. Let me ask you, I mean, I just found it so unbelievable. Oh, she told me she was bleeding out. She's bleeding out. And oh, well, she was having a little difficulty. Her voice was a little hoarse. What do you make of this testimony?
That was so incredible to me. I don't know, I'm not a physician, who knows, but I don't know that hoarseness would be the effect of aspirating your own blood, which I think would be the primary hindrance to her communicating. And that really was the suspicion that a lot of folks would have, that, if she is bleeding out, that would be evident. She had a clotting disorder that he knew about. Would she be hoarse, or would she be choking and aspirating on the blood? And then pairing that with the priorities of what she chose to share with him by his own account, which is, a lot like him telling his credentials to 911 and bringing them up as frequently as possible. Her priority, according to him, was how much she loved him, not their daughter, not any other things that she wanted to share about the circumstances or telling her parents anything, but I love you so much. By the way, I'm dying and I know this. And then those are the only things that she has to say. I'm not buying it.
Mackenzie, let me ask you a question. You have a client who, if he says he wants to testify, you'll have him tell you the story that he wants to tell. And he tells a story that includes those types of details which don't make any sense to you listening to it. I agree. There were a number of things when he testified that I was like, if I heard that, and he was my client, I'd say, maybe we want to rephrase that or look at that a little differently. I try to steer him in a different direction. What would you do if you had someone who was insisting on taking the stand, but there were parts of their story that just didn't quite add up? How do you handle that?
Yeah, I think that's a very challenging situation because he clearly had things that he wanted to share. I thought that about the sad affect that was kind of weakly performed. He essentially just made like a sad face through his direct, but immediately dropped it on cross, even when the same emotional topics came up. And I think that as his attorney, it would have been much more prudent to, presumably they rehearsed these exchanges to some extent, to be straight with him. Say, look, your sad face, I'm not buying it. So try a different tack. Go for I'm going to be strong and stoic and try to sell that. Try to see what he can act best, because what he ended up selling doesn't work. And the only reason I can think for not addressing that beforehand is trying to spare his feelings. Or, maybe he put his foot down to the extent that a client can with those sorts of decisions. And he's like, no, this is convincing. I'm going to go with this. Now, the story elements that you're referring to, I wonder if they didn't prep those sorts of things, but he still went rogue. Because that is certainly something that any good attorney would say, yeah, that doesn't make a lot of sense. Or let's find a way that could make sense and re-describe it. But he went rogue. That's the only thing I can think, because that's such an obvious hole in their story.
Yeah. And Judge, I can't imagine, or I can't imagine that he is that type of person. Just listening to his testimony, watching him throughout the trial, seems to have a very strong personality, very confident personality, very law enforcement type personality. So it doesn't surprise me if that happened.
I agree with you. If he went rogue, it wouldn't surprise me either. Now, of course, we have to keep in mind, you and I talked about this yesterday, you always have to tell your client, tell the truth. But the way in which they tell the story is strategy that you can help shape.
Absolutely. Or you can help them remember better. Sometimes they're not remembering straight. Are you sure that happened that way?
Right.
Are you sure this, you know, so those types of things. But yes, you don't want to tell them to lie.
Right.
Do not do that.
No, right. But interesting story he did tell. Coming up next, though, we are going to turn to New Jersey for testimony from the Mansion murders trial for Paul Canero. Find out what the lead detective says investigators found at the victim's home.
An affair with the family's au pair lead to double murder.
I'm gonna kill her. It's a case of sex, lies, and deadly deception.
The Au Pair Affair murder trial. Live coverage today on Court TV.
Tonight on closing arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest verdict watch updates.
Closing arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
The fate of defendant Brendan Banfield is now in the hands of a jury. They've been deliberating now for just over an hour.
He is accused of being the mastermind behind an elaborate plot to lure an unsuspecting man to have violent sex with his wife, Christine, and then frame him for her murder. We will bring you into court, of course, if there's a jury question and when there's a verdict.
All right, first we are going to turn now to New Jersey for the Mansion murders trial for Paul Cannaro. Court is dark today and testimony is set to resume on Monday.
Cannaro faces life in prison if he is convicted of killing 4 members of his own family back in November of 2018. The body of his brother Keith was found on the front lawn of his home. Keith's wife's body was found inside the house along with the bodies of their 2 children.
Prosecutors say that Paul killed them because Keith found out that Paul was stealing money from their joint businesses and threatened to end Paul's salary. All right, we're going to go into court now, but before we do, let's get you caught up on the case.
We allege that the defendant repeatedly shot and killed his brother while he was outside of the side of his home, and then moved to murder the rest of the family inside the home.
Paul Cannaro is accused of killing his brother and his brother's family and then setting their mansion in Colts Neck, New Jersey on fire to cover up the brutal murders. 50-year-old Keith Cannaro was shot in the head and in the back. His wife, Jennifer, was shot and stabbed. Their 11-year-old son, Jesse, and 8-year-old daughter, Sophia, were both repeatedly stabbed. Investigators say after killing them, Cannaro set fire to their home to destroy the evidence.
Sir, what are you reporting? Okay, fire.
A neighbor called 911 when he noticed the Cannaro house was on fire. Then he saw a body.
Oh, my God, there's blood here. It's a corpse. It's what? It's dead. What's dead? There's somebody's dead here.
Prosecutors say Cannaro also set his own home on fire the same day in nearby Ocean Township, New Jersey.
That fire was effectively a ruse designed to make it appear as if the overall Cannaro family was somehow targeted.
Prosecutors say Paul Cannaro's motive was money. Keith and Paul Cannaro owned a tech firm and a pest control business together. And according to court documents, Keith was about to cut off Paul's salary after finding out he had stolen tens of thousands of dollars from him.
This one is the most brutal case that I've seen in my experience here.
Cannaro was indicted on multiple charges, including 4 counts of first-degree murder. He pleaded not guilty and maintained he had nothing to do with the murders. All right, what we want to do now is bring you key moments from the trial from earlier this week when we were covering the Brendan Banfield trial. We're going to pick it up now with testimony from the lead detective in the case, Stephen Vogt. Here, he's on direct by the state.
Okay, so let's talk about November 20th of 2018. What, if any, notifications did you receive?
I was notified by, at that time, Sergeant Ryan Muller of the crime scene unit and advised to respond to 15 Willowbrook Road in Colts Neck.
About what time did you respond?
About 2:51.
Okay, and who, if anyone else, was already there from the crime scene unit in the prosecutor's office?
So specific to the crime scene unit, Sergeant Muller was on scene, as well as Detectives Cordoma and Flanagan.
Now, were you ultimately assigned as the lead detective from the crime scene unit?
Yes, I was.
Okay, and what does it mean to be a lead detective?
So being the lead detective essentially means that, especially in a large-scale investigation like this, there's going to be a lot of detectives involved. I believe every detective in the crime scene unit have had a role one way or the other throughout this investigation. But as the lead, all evidence, all photographs ultimately funnel their way to me. That might be through the evidence as it's being collected, maybe in another scene, because I can't be in 2 places at once, is going to be brought back to the crime scene unit's temporary evidence vaults, and ultimately it gets put into my custody. And the reason we do that is to ensure that nothing gets missed. We want to bring it in, and then those decisions are made by the lead as to what the next steps are. And again, just so that I'm reviewing and understanding everything that's going on throughout the investigation.
So you're essentially like the point person?
Yes, I'm the evidence custodian, if you will.
Did you write a report in this particular case?
I did.
Okay, you wrote several reports, right?
Yes, I did.
Did you write your first report in particular on February 1st of 2019?
Yes, I did.
Okay, I'm going to show you what's being marked as S-275. May I approach, Judge?
Okay.
I'm showing you what the mark is S275. Is that your report that you wrote on that date?
Yes, it is.
Okay, I'm just going to ask you, if you need to refer to your report, just please let us know.
Okay.
Can you lay out the scene for the jury as to 15 Willowbrook Road when you arrived?
Sure. Upon my arrival, so 15 Willowbrook Road is a large property located on the south side of Willowbrook Road. That's in between the intersections, as I mentioned earlier, of Route 34 and Evergreen Lane. Upon my arrival, I ensured again that the crime scene was secured, which it had been by fire police were at those intersections, basically making sure that no unauthorized vehicles came in. There were multiple fire department members and trucks lined up along Willowbrook Road, as well as in the scene to ensure that, because there was active and ongoing fire suppression efforts going on. So there was still a very active fire at that time, to include heavy smoke emanating from the interior of the house. It was approximately 47 degrees and cloudy on that day. And I was advised upon my arrival, what I knew right away was that there was one male victim deceased on the front lawn.
Now, you talked about how there were other crime scene unit detectives from your unit on scene already.
Yes.
Were there any other officers or detectives from the prosecutor's office on scene when you arrived?
Yes.
Who was that?
I spoke with Detective Patrick Petrozello, and not from the prosecutor's office, but also Detective Rich Cirillo from the Colts Police Department. But they were on scene from the major crime, or at least Pat was, from the Major Crimes Bureau.
Shortly after you arrived, did you and they and the other officers from your unit engage in a field briefing?
Yes.
What is that?
So we meet, especially for homicides, but in general, we always want to meet, and two reasons. One is to assign roles. That was really at that time when I was assigned as the lead forensic detective. I was also advised of everyone else's role within the crime scene unit. Sergeant Ryan Mueller was supervising as well as assisting as needed. Detective Flanagan was assisting as needed. He had already taken several photographs prior to my arrival. And Detective Cordoma was assisting from a crime scene standpoint, but was also responsible for the origin cause investigation as well as electrical wiring documentation.
So as a result of that field briefing, did you learn any information that happened or things that occurred prior to your arrival?
Yes.
And was that helpful to you in terms of your job as the lead detective from the crime scene unit in terms of processing the scene?
Yeah, so it's just getting an overall understanding of the scene. Like I said, the fire was still active. Fire suppression efforts were still going on. Detective Flanagan had taken a series of overall photographs of the scene, and we want to do that, especially in a fire, as early as possible. So he was obviously there earlier. So he took those photographs, and it helps with the origin and cause investigation. It showed, heavy flames coming there, specifically from the photographs from the rear of the property showed heavy flames coming from the interior of the residence, and generally speaking, where those flames are. We also, I'm sorry, can you repeat the remainder of that question?
Okay, I was actually going to ask you if you could, along those same lines, if you could tell us who, if any, victims did you learn about? You already mentioned the one, but can you please just describe for us all of the victims and their names and their locations?
Sure. So I was advised that Keith Canaro was located in the northwest of the property, or northwest of the building. He was deceased and covered with a tarp. That tarp was utilized by fire personnel. Jennifer Canaro, her body was located inside the foyer. So basically, if you walk through the front door, make an immediate left, there was two sets of stairwells. One's going up and one was descending down to the basement. Jennifer Canaro's body was...
So the fire was still active when they arrived. Up next, we're going to hear where those children were found. More testimony from the murder trial for Paul Canaro in New Jersey up next.
Welcome back to Court TV Live. I'm Michael Ayala here with Judge Ashley Wilcott, and we are on verdict watch in the au pair affair double murder trial for Brendan Banfield in Virginia. The jury has been deliberating now for 1 hour and 19 minutes. Of course, we'll keep a close eye on the courtroom where if that jury comes back with a verdict or a question, of course, we're going to bring that to you live.
And now we want to turn to New Jersey, though, for the mansion murders trial for Paul Canero. Court is taking a break today, so court is dark, and we want to use this time to get you caught up on key testimony that you may have missed.
Prosecutors say that Paul Canero killed his brother Keith, his brother's wife, and their 2 children, and then set their mansion on fire to try to cover up his crime.
He's also accused of setting his own home on fire to make it look like they were both targeted. Some crazy cases these days. We're going to pick it back up where we left off with lead detective Stephen Vogt still on direct.
Was located on the floor in the foyer with her head on her back, with her head facing roughly towards those descending stairs. The ascending stairwell directly to the left of that is moving up to a platform, which ultimately leads to the second floor. I was advised that Sophia Canero's body was located on that platform area. Firefighters had removed her body from the interior of the scene and brought it out to the front porch area. Detectives, again, prior to my arrival, detectives had placed her body in a transport body bag and ultimately brought her to a pop-up tent, a temporary pop-up tent area that was created on the driveway. And lastly, Jesse Canero's body was located in the kitchen. Detectives had removed his body from the scene and placed it in a transport evidence bag, or transport body bag as well. He was brought out to that same pop-up tent area.
Now, did there come a time when you went inside of the house?
I did. So the decision was made because Jennifer Canero's body was still inside the house. They were having difficulty getting in there prior to my arrival, but the decision was made to enter the house again. While we did that through that foyer area, I did capture some photographs of that area as best I could. And then we entered for the purposes of removing Jennifer Canero's body from the scene. She was also placed in a separate transport body bag and brought to that same pop-up tent area.
Okay, so just in terms of the scene now, you have Jennifer and her 2 children's bodies are under the pop-up tent?
Yes.
And then Keith's body is still where it initially was when you arrived?
Yes, ma'am.
At about 3:10 p.m., did you begin processing the scene?
Yes.
Okay, and what specifically did you do first?
So I first documented Keith Canero's body under the tent. We were still waiting for investigators from the Middlesex Regional Medical Examiner's Office to arrive, but I documented the location of his body as well as what it looked like. His body was covered with a white sheet and then a red tarp. So I wanted to document that location, but also document any evidence that was visible in that area. There was a cellular phone located on the grass to the east of his body. So essentially where he was located, like I said, was in the, if you're standing on the street looking at the front of the residence, I think going forward I'm going to explain it this way, it'll be easier, but it was the front right of the property was where his body was located, and his head was facing roughly north towards the street, away from the residence. So east of that of his body was his cellular phone. So I documented and collected that phone for 2 reasons. One, I knew that as the medical examiner's office arrives on scene, they're going to obviously do an on-scene examination. I didn't want anything to happen to that cellular phone. But I also wanted to get it into hands of the computer crimes unit as quickly as possible.
Now, overall, on November 20th, did you take photographs of both the inside and outside of 15 Willowbrook Road?
Yes, I did.
And did you also take photographs of the property and the inside of the property on several days thereafter?
Yes, I did.
I'm going to show you. What has been marked as S1C. I'm showing counsel. Sergeant, do you recognize this?
Yes, I do.
And just in there, what are those?
These are the photographs throughout the investigation, but particularly the photographs I took at 15 Welbrook Road.
Are they, and let me just ask you, you and I sat down and in preparation for trial, we painstakingly went through the numerous photos that you took, is that correct?
Correct.
And we narrowed down the ones for purposes of trial so we don't have to show every single one of them, is that right?
That's correct.
Okay, the photos in there, are they a fair and accurate depiction of what the scene looked like at the time you were photographing it?
Yes, ma'am.
Okay, I can take that. Judge, permission to publish specific photos.
Any objection? No. Okay, sure. We drop the lights.
Please have slide 120. Sergeant, what are we looking at here?
So, as I referenced earlier, if you're stepping through the front door, turn to your immediate left, facing east. There's two sets of stairwells. The ones to the left of this photograph are the ascending stairwell that run along the front of the house, leading up to the second floor. That, it's difficult to tell, but that to the right of that is the descending stairs. Those lead into the basement. There's heavy smoke throughout the residence, but particularly coming up through that basement area. Jennifer Canero's body is located just at the top of those stairs that lead into the basement, and their yellow tarp was placed over her body by fire personnel.
So just to be clear, Jennifer's body is located under that tarp in this picture.
Correct.
Can we please have slide 121? Just a little bit of a different angle.
Yeah, so just kind of going forward, the way I take my photographs, especially the overall photographs, is working in a clockwise direction as best I can, and then panning from left to right. It doesn't have to be left to right, just the way I do it, but so I'm taking overlapping photographs. If I were standing in each corner of this courtroom, for example, I'm going to photo this area so that they overlap slightly so I don't essentially miss anything. So that's what we're doing here. I'm standing in the same
All right,
area.
let's bring back in our guest. Still with us, trial attorney Mackenzie Joy Brennan. And Mackenzie, one of the tacks that the defense has taken in this case is that they're challenging the investigation into the case. Well, now we have the lead detective on the stand. So I imagine this is very important testimony that prosecutors are being very careful with, but also the defense has to really prepare for the cross-examination.
Yeah, you know, I feel for the defense in this case because it seems like an incredibly hard job with the fact pattern that we have. So far from what I've seen, a lot of their arguments are essentially, you know, my client couldn't have done this because it is so absurd. But the absurd thing already happened. The absurdly tragic thing, somebody had to have done it. So I think that they're really pigeonholed with the kind of defenses that they can make because, you know, arguments like, well, it wasn't enough money and maybe it was the other brother. The crazy thing happened, and the most likely scenario is that this guy did it. Now, from what I saw of the expert yesterday, I also saw some compelling investigative-based arguments that, you know, people knew their attackers, if memory serves, that the bullet wipe gave some indication that somebody didn't flee. So it sounds like a lot of the investigation is pretty solid too. And this guy who's on the stand now, he is coming across very credible. So I'll be interested to see what the defense does with this. I feel like they're grasping at straws a little bit just because the facts of the case are so awful and so stacked against their client.
Yeah, and I think the fact that you're referring to is that on the jacket of Keith Canero that he was in that night, the distance of the gun to the jacket was very, very close.
Right.
So the sense is that, you know, this person was able to walk right up to them.
Right, and I just was gonna ask you about some of those details because it's so personal in nature. I think when you hear the 2 children were stabbed in the face, there was a yellow tarp that we just saw through this witness's testimony put on top of the mother of the children. These kinds of things to me scream it had to have been personal.
Yeah. Oh, absolutely. And the fact that the brother's own house then was found on fire, but the only distinction between the 2 cases is that there wasn't a murder first in his case. I mean, how do you get out of that scenario? And the fact that he did kill the children, especially given that the parents, you know, were not intended to survive, it seems. And I could really see that as the only quote unquote logical reason for somebody killing the children is to hurt the parents, but that's just unhinged. It just seems rage-based.
I agree. Unhinged, rage-based, I think are great terms for that.
Yeah, the other difference between the fires was the one set at Paul's own house wasn't nearly as dangerous as the one he set in his brother's house. So there's that as well. All right, Mackenzie, stand by. We're going to take a break. Folks, when we come back, we'll have more testimony in the murder trial of Paul Canero. We're going to hear about Keith's death. When we come back, keep it here on Court TV.
An affair with the family's au pair lead to double murder.
I'm gonna kill her. I'm gonna kill her. It's a case of sex, lies, and deadly deception.
The Au Pair Affair murder trial. Live coverage today on Court TV.
Tonight on closing arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest verdict watch updates.
Closing arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
right, folks, we're going to get you back to Jersey in just a moment. But first, we are on verdict watch in the au pair affair double murder trial for Brendan Banfield in Virginia. The jury has been deliberating now for 1 hour and 34 minutes. And of course, we're going to be keeping a close eye on that courtroom. And when that jury comes back with either a verdict or a question or anything at all, we're going to bring that to you live.
I wonder how long that jury's going to be out. We don't know. I think it's going to be a while because there are a lot of details.
Yeah, there's a lot to go through.
A lot of details were provided. All right. While we were bringing you live testimony from the Brendan Banfield trial, another major murder trial was taking place in New Jersey, the Mansion murders trial of Paul Canero.
Now, prosecutors say that Canero shot and killed his brother Keith, Keith's wife, and stabbed their 2 young children to death before setting their home on fire.
Now, they say he did it because Keith had found out that Paul was stealing money from the family business. Court is dark there today, so we're bringing you key unaired testimony. We want to pick it back up with the lead detective, Stephen Vogt, on direct examination by the prosecution, describing where the bodies were found at the home.
Okay, so that's what we're doing here. I'm standing in the same area, just panning to the right. You can see that yellow tarp to the left of this photograph. And then obviously the smoke.
Sorry, can we please have 122?
This is just a more close-up photograph of those stairs and the tarp where Jennifer Canero was located. Again, her body, she was found to be on her back, facing the stairs, the descending stairs, with a significant amount of debris on top of her body, as well as, again, that tarp.
Did you have the opportunity to make observations about Jennifer's body?
Yes, I did.
What observations did you make?
She had extensive fire injuries throughout her body, to include charring, skin splitting, soot deposits throughout pretty much the entirety of her body.
We could please have slide 123. Sergeant, what are we looking at here?
So this is a photograph of that area where Keith Canero's body was located. Again, he's at northwest of the structure. That tree, for reference, you're going to see a lot of different angles of not only Keith Canero's body and this tarp, but also that area in general. So this tree is a good reference to kind of pointing you towards the residence, so you have an idea of, orienting what we're looking at.
Just in terms of your process, is this the next place that you went after you removed Jennifer's body?
Yes, it is.
Okay, if we can have slide 124.
Again, just moving in a clockwise direction around that area and around the tarp.
125, please.
Continuing, I'm facing roughly west at this point. Just photographing another angle of the tarp in that area.
That tree, was that tree like that when you arrived?
Yes, it was.
Okay. And if we could have 126.
The reason we removed part of the tarp at this point, we were still pending or awaiting the medical examiner's office to arrive, but I wanted to document again that cellular phone next to the body prior to collecting it.
Okay, and then 127, please.
This is another mid-range photograph of that cellular phone, just to show where it is in relation to everything else.
Okay, and you indicated earlier that you had collected the phone as evidence?
Yes, I did.
Okay, and just can you tell us how you packaged it, what you did?
It got packaged in a individual paper evidence container or an envelope, and it was ultimately turned over into the custody of Sergeant Broccolieri from the Computer Crimes Unit.
Why was it turned over to him?
Because he's ultimately going to be doing the processing of that cellular phone. That's his job. Or at least somebody from that unit is.
I'm showing counsel S295 and S300, the phone evidence receipt. I'm going to show you what's been marked as S295 and 300. Do you recognize those items?
Yes, I do.
Okay, let's start with S295. What is that?
S295 is the evidence property receipt of items that were collected from the scene on the 20th.
Okay, and is that specific phone that is marked as S300? Let me ask you, what is S300?
S300 is that same phone that we just saw the photograph of. It is, so just quickly going into our label here, so that all of our evidence gets put into a computerized system and generates an individual number. So the number for this case, or at least the Colts Neck aspect of this case, on all evidence is 18-0832. So that's going to be consistent throughout. We then move on to the log number, which is log 1, because all items from the scene, we try and separate as best we can log-wise, just to separate scenes. Log 1-1. So ultimately it's 18-0832-1-1 is a black Google Pixel 3 cellular phone and case recovered from the grass next to the body of Keith Canaro.
Okay, and essentially is the reason that, so you have your numbers on there that you generate, right, from your unit?
Yes,
Okay, and that's so you can track things, is that right?
that's correct.
Okay, and then if something gets sent out to another agency, will that agency then put their sticker on it as well with their own number?
Correct.
Okay, and then when it comes back to you, you'll be able to have your tracking number as well as the agency's number, is that right?
That's correct.
Okay, and the evidence property receipt that should correspond with that?
Yeah, so the evidence property receipt is tracking chain of custody. So that's the reason why there's.
Goodbye to Mackenzie Joy. Brennan, thank you so much for joining us today.
Folks, stick around because coming up, we're going to be bringing you more testimony from the mansion murders trial for Paul Canaro. Plus, in New York, a judge has just made a major ruling in the case against Luigi Mangione. The ruling clears the way for his federal trial to begin in October. We're going to have that and more coming up here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. The fate of defendant Brendan Banfield is now in the hands of the jury. Now, that Virginia jury, they've been deliberating for about 1 hour and 45 minutes. Prosecutors say that Banfield killed his wife, Christine, and another man, Joseph Ryan, as part of a plan to run off with his mistress, the family's au pair. But the defendant refutes that claim, saying on the stand that he played no part in the catfishing murder plan. And we're going to bring you into court if there is a jury question, of course, if there is a verdict. But right now, here's a look back at key moments from today's closing arguments.
There has been a plethora of evidence to help you meet your burden in this case. Let's walk through just the highlights. Our digital evidence. While the digital evidence cannot tell us definitively who was behind the screen, we heard that a bunch. We know that to be true. What it can tell us is that Brendan Banfield and Juliana Perez Magalhaes are more likely to be the ones to have set up Joe Ryan to come into the house to fake rape Christine on February 24th. There is no digital history, none, of Christine Banfield using dating sites, fetish sites, searching for pornography, talking to other men prior to the January inception of this scheme. If you think that Juliana Perez Magalhaes and Brendan Banfield were working together to kill Christine and Joseph Ryan, then Brendan can be responsible for Joseph Ryan's death, regardless of which bullet did the most damage. It's not a test of either or. They were working together. That makes him equally responsible. But at the end of the day, I don't think that there can be any reasonable doubt that Mr. Banfield has committed each and every one of the offenses that we have put before you today.
There are numerous things that became the centerpiece of the fantastic story that the Commonwealth tells, yet they were never tested. For example, if I were to have the opportunity to cross-examine, say, the chief detective of this case, I might ask, why wasn't there fingerprints done, or even DNA, of this gun safe that we hear about? Juliana made it up. She told the Commonwealth what they wanted to hear, and without question, they just took it as their story. She told this lie to secure herself a deal that benefited her. This one event relating to digital forensics is reasonable doubt, because every other event going forward requires Brendan, based upon her statement that she didn't have anything to do with it, she didn't know how to do the Gmail account, she didn't know anything about the setup, requires Brendan to be involved, or Christine.
The defendant took the stand and he lied. And he lied about collateral matters. He told you that he had a big career-defining work meeting the morning of the murder. And then you heard from his boss, who said, no, he didn't. He lied. He said that he and Juliana did not have a plan to kill Christine at the time that they went to the shooting range. Well, he said, not at that time. If he's lying about the things that don't matter, how can you believe a single word he said?
Let's welcome in our guest for this hour. Joining me is trial attorney Gabriel Sepulveda Sanchez. Gabriel, great to see you. It's been a little while. Hope you're doing well. Thank you so much for joining me on the program. I want to get your thoughts on closing arguments. I thought this was the type of case closing arguments could have certainly made a difference. There's enough there to work with really on both sides that if it was crafted just right, could have moved the ball a bit. What did you make of closings?
Yeah, I thought they both were good closings. You know, I think at the end of the day, it just really comes down to credibility. I really just, the prosecutor, she pointed out those inconsistencies, and whenever you have, you know, a defendant testifying for themselves or making inconsistent statements, you know, that's you just how it's just the jurors are going to look at who's more believable, who's credible, you know. So I think the jury's going to come back with the guilty verdict, and based on just the inconsistencies she's highlighting. And I think there's more than a few that she pointed out there. That's a big deal, you know, when a DA gets point out how, you know, make you look less credible and just catch you in lies, and the whole statement about him wanting to go to work or having a big career-defining meeting and his boss saying this is not true. You know, those things it's not a good look at all. And I think the jury's going to see right through it.
Yeah, I would agree. She did a great job of pointing out some of those inconsistencies, and I think you're right. We're at the point now, when he took the stand, it really became him against Juliana Magalhaes, right? Who's more credible to this jury? Let's take a look at something Juliana Magalhaes testified to. This is a key moment. She says she saw Brendan stabbing his wife. Let's take a listen.
And a few times I looked, and I was able to see him stabbing her, and he would stab, and other times he would hold the knife in a position how that was.
Gabriel, I got to say, once she finished testifying, I wasn't completely sold. And as the defense went through their case, especially when they brought on that forensics examiner with some of the information about where the phones were, or where the defendant and Juliana's phones were when things were happening on the computer and on the victim's phone, I said maybe they got a shot. But once they took the stand, I think it was a big mistake.
Oh, yeah, definitely. Yeah, you don't, I mean, just putting, when you're making a big, even if you are innocent, and you go on the stand as a witness in your own defense, you're going up against a skilled cross-examiner that's going to find any way they can make you look like you're not credible. And it could be things that are immaterial. You're going up against a professional. So you can be, anytime, even if you're innocent, you're taking that witness stand, they're going to find something. You know, if you look hard enough, you'll find some sort of detail or inconsistency or something that just didn't line up. And I thought that was a big risk by them doing that. But sometimes it's one of those things like it's the defense attorney's call, it's just judgment call, and you know, but it will figure out if it worked. But big risk doing that. Even if you're innocent, you got to really think about whether you want to put yourself through a cross-examination, because it's not fun. And we know what we're doing as lawyers. We're going to find a way to test your credibility in any way we can. That's what we're trained to do.
Now, when we look at Juliana and her motivation here, to me, she seemed to have maybe even more motivation than the defendant. But I think the big problem for the defendant here is the power differential between the two. She was basically a 21-year-old au pair from a different country. And then here's this guy, and according to his testimony, she was the first one to kind of breach this sort of professional relationship and sort of moving more towards this personal relationship. But again, how much is that power dynamic going to affect the way the jury looks at their relationship and who might be responsible?
I think so. And, you know, if you look at her while she's testifying, you can see your jurors look at your behavior and they watch everything and your tone and they, you know, I think she came off credible to me. And I think she looked, you know, pretty sincere and kind of had an innocent sort of, you know, that I didn't know what was going on kind of, you know, look. So that could be, I think that might play to their advantage. You know, so that's based on how I'm seeing her testify.
Yeah, no question. Now, Banfield, when he took the stand, he talked about a lot of things. And one of the problems was he gave so much detail about things that he probably shouldn't have given so much detail about because, again, it opened him up to all that sort of credibility issues. But I want to take a listen to something he said about what his wife did during this whole ordeal. And the state pointed out rightly, when she did this, what he's talking about, she would have been stabbed 5 or 6 times at this point. So let's take a listen.
The day was an important day for me at work as well. There was an important meeting for one of my cases. That meeting was scheduled for 9:30 that day.
To your knowledge, was there a meeting scheduled between yourself or with Juliet and Mr. Banfield on the morning of February 24th, 2023?
Leading.
Were you scheduled to meet with Mr. Banfield?
I was not. Leading out. And that she was sorry and that she loved me.
And she's chatting with you with these wounds in her neck, correct?
Yes, her voice is very hoarse. She was having difficulty speaking, but yes, she was talking to me.
So this goes back, Gabriel, to this credibility issue. The first witness we saw affects his credibility. He was called on rebuttal to say that, look, he talked about having a meeting with me, and that meeting was never scheduled, so there's that. Then you also heard him talking about, and this is where I lost it, when in terms of trying to figure out if I was going to believe him, where he talked about her talking to him under those circumstances when she had already been stabbed in the neck.
Yeah, that's that's kind of like a movie. That's kind of like a horror movie. Like I have a horror movie,
exactly.
Nightmare on Elm Street. It's one of those things where, that's not when you're getting. I'm assuming that when you're getting stabbed in the neck, the last thing you're trying to do is talk. You're just trying to get, fight for your life or get help. So, yeah, and you have that. That just doesn't make sense to me. And if you look at all that blood, this isn't. No, there's enough damage being done to her neck, or that you're not going to be talking. It looks like just based on that. I think George's going to look at that. I'm like, I don't think they're going to believe his statements. And then having this credibility, he lost credibility there, making that statement, and also setting it up that he had a meeting that day with his boss, and those things matter. And the DA just exploited that. I don't think it was a good idea for this guy to testify. Looking at him right now in video, it's the first time I've actually seen him testify on video.
Yeah.
Yeah, I don't.
Yeah,
sometimes
it's when you take the stand, when you take the stand, Gabriel, there's two things you want to accomplish. You want the jury to like you, and you want to be credible, and he was neither. But anyway, let's move on. Yeah. We're also following another case. Folks, the following developments today that happened in New York. That's where a judge has ruled that Luigi Mangione will not face the death penalty if convicted on federal charges. Now, the decision is a blow to federal prosecutors who have been pursuing the death penalty in Mangione's upcoming murder trial for the shooting death of United Healthcare CEO Brian Thompson. The judge also ruled today that evidence found in Mangione's backpack will be allowed in at trial. Now, these rulings now clear the way for his federal trial to start in October. Now, as for the state trial and those state charges, prosecutors are asking for that to take place in July ahead of his federal case. And again, there is no death penalty in New York, so that's not on the table there at all. Let's bring back in our guest, still with us, of course, trial attorney Gabriel Sepulveda Sanchez. Gabriel, I want to get your reaction to the death penalty being off the table in this case.
Well, that's a big win for the DA, the defense team, definitely. Especially with it seems like there's overwhelming evidence in this case too, and such a high-profile killing. That's to get the death penalty off on the federal case is a big win. As far as it doesn't mean that. I think people were asking me this morning, is he acquitted? That's not an acquittal. He still has to deal with New York state law. I think there's probably charges pending, or they're planning on prosecuting him under New York state law. So it's a little more complicated. It's not an acquittal. It's really just under that statute that they just, there was some sort of legality where they were able to take the death penalty off the table. So I'm not sure what it was, but I know that, there's a state court level and there's a federal court level. So he's still got to answer for crimes under the state court level. I don't know if he can still be faced with a death penalty on a state court level. I'm assuming not, but he's still got a lot to deal with in the future.
Yeah, it's in New York, so there's no death penalty in New York, Gabriel. So no, death penalty is completely off the table for this guy. And again, if the evidence is as it appears to be, he will end up spending the rest of his life behind bars, but no death penalty for him. I want to get your thoughts on this guy's popularity. A couple things happened. Someone dressed up as a security guard tried to get him out of jail. People were cheering outside the courthouse when they heard the judge's decision of no death penalty. What do you make of his popularity?
I always question that too. He's not a bad-looking guy. And it's just like I think that might have something to do with it. So I think people are kind of funny. I think when Richard Ramirez had fans too, the serial killer, and it's just people are bizarre. I think we both know that. You know, when he's got a smile, looks a little charismatic, well dressed, young. You know, I think you're gonna, out of the pool of people, you're gonna attract people out there that are gonna support you based on your physical appearance. I think that's what it is, but I don't know. And also, I think people are also, you know, there's also some people really hate the insurance companies. You know, and they think that it was awful what he did, but maybe it saved lives. That's some people I've heard those arguments too. Like in the grand scheme of things, you know, by denying health benefits to Americans, there's actually talks, and I don't know if it's backed up, that after he died, the claims adjusters were approving healthcare benefits, and they're delaying the denial of claims, like decrease for a period of time. I don't know if that's true or not.
Yeah,
but there's that argument. Some people think what he did was good.
I haven't read that. If that was in fact an effect, I think certainly that's what his supporters are looking for. I don't know if there's a cause and effect there, and I don't even know if it happened, but I think you're exactly right. I think those two things are absolutely in play. He is a good-looking guy, and also people are just not happy with the way insurance sort of works. All right, Gabriel, stand by. We're going to take a break here. When we come back, we're going to turn back to New Jersey for more from that murder trial for Paul Canero in New Jersey. More about the deaths of those victims and what they found at that crime scene. Keep it here on Court TV.
Did an affair lead to double murder?
The Commonwealth's Attorney's Office has secured an indictment against Brendan Banfield for the murder of his wife, Christine, and the murder of Mr. Ryan.
Prosecutors allege the defendant planned to run away with the family's au pair. So he killed his wife and another man.
He was there. I'm gonna kill her. I'm gonna kill her.
It's a case of sex, lies, and deadly deception.
The Au Pair Affair murder trial. Live coverage today on Court TV.
Well, folks, we'll get you back to testimony in the mentioned murder trial for Paul Carrolll in just a moment. But we do want to remind you that we are on verdict watch in the trial for Brendan Banfield back in Virginia. Now, the jury has been deliberating for 2 hours. We're going to bring you into court if there's a jury question or if there's a verdict, of course. And also, I want to tell you about something that's happening on our Facebook page, our YouTube channel, and on X. We're asking folks, what do you think the verdict will be? Now, over 4,000 of you have already voted, and right now, over 90%, I believe it's closer to 94%, say that Banfield will be found guilty. And a tiny, tiny percentage think there might be a hung jury, but I don't know. We'll have to see. All right, I want to get you back to New Jersey now for key testimony in the murder trial against Paul Carrolll. Prosecutors say that Carrolll shot and killed his brother and his brother's wife. He's also accused of stabbing to death the couple's 2 young children and then setting both of their homes on fire back in 2018. Now, we're bringing you key testimony from earlier this week while we're covering that Banfield trial. On the stand now is the lead detective. His name is Stephen Vogt, and he's still on direct by the state.
That's the reason why there's 2 separate things here. That chain of custody just shows that all the items collected were from the scene to me on the 20th, and from me, or at least for the cellular phone, into the custody of Detective Richard Brocolieri on the 20th, and the remainder of the items, which we'll discuss, went into the crime scene unit's temporary evidence vault. So all aspects of anytime anything is collected throughout our investigation, we have to show custody of it throughout every step of the investigation. If it goes into our temp vault and then it goes into the main evidence vault, we have our own separate tracking of that. If it goes to another lab, we have another receipt for that, so we're showing all those steps.
Now, on that evidence property receipt, is every item that you collected on November 20th listed on there?
Yes.
Okay, I'm going to take the phone back from you, but I'm going to leave that receipt with you for the next items. Thank you. If we could please have slide 128. Sergeant, what are we looking at in slide 128?
So this is the back right deck, which would be the southwest deck of the property. That cone in the middle of the photograph is a picture, was placed there by Colts Neck Police. It's covering a large unspent cartridge that was at the scene. The reason that they put the cone there is because there was a lot going on, obviously, fire suppression, and a lot of firefighters going in and out. They didn't want anything to happen to that item, so they covered it with the traffic cone.
Now, in terms of the order of your process, tell us when you came over here to this area.
So it was subsequent to documenting the phone near Keith Carrol's body. I was advised of the location of this live cartridge or unspent cartridge, and the reason that I documented it as quickly as I did is the same reason that they put a cone over it, is I wanted to collect it kind of as quickly as possible so nothing happened to it.
Okay, and if we could have slide 129.
It's a mid-range photograph of that cone. Just quickly going, I talked about my overall photographs. All of our photographs are working from outside in. We start with overall photographs to document the scene, all aspects of the scene, moving into mid-range photographs where we're documenting any items that we feel to be of potential evidentiary value or importance in relation to one another, in relation to this table, for example. So we want to capture that location, like I said, to orient what we're looking at.
And finally, 130.
That's a close-up of that live cartridge from the deck.
Okay, and was that packaged and labeled by you?
Yes, it was.
Okay. Do you recall, was there a head stamp on it?
Yes, I do.
Do you recall what the head stamp was?
I have to refer to my report.
Is it on the evidence property receipt?
It is, yes.
And what item is this on the evidence property receipt?
Item number 2.
Okay, and is the head stamp listed on there?
So the item is listed as live cartridge, head stamp GFL 10 9x19 from under traffic cone and placed by Colts Neck Police on paved deck southwest of the property. That GFL stands for is the make, which is Fiocchi. 9x19, it generally speaking is just describing it as a 9mm caliber cartridge. And my understanding of the 10 is that it's the manufacture date.
Show my counsel what's been marked as S301. Sergeant, do you recognize that?
I do.
And what is that?
That is that live cartridge. It has two different envelopes here. This is my envelope, which has the label created as 1-2. This is the envelope that ultimately gets sent to New Jersey State Police Ballistics Lab. They have their own envelope with lab number C as in Charlie 18-10138, number 10. And then this is the cartridge itself.
Thank you. At about 4:00 p.m., did anyone from the medical examiner's office arrive?
Yes.
And who was that?
Investigators from the medical examiner's office were Elise Parker and Ray Coran.
And what specifically did they do?
So they were there specifically to conduct on-scene examinations of the bodies. My photographs at that point were ultimately at their direction, but they were doing on-scene examination prior to the bodies being brought to the Middlesex Regional Medical Examiner's office for autopsy or post-mortem examination.
Did you accompany them when they went to each victim?
Yes, I did.
If we could have slide 131, please.
So during that on-scene examination, this is a photograph of Keith Canero's body. Again, for reference, his head is pointing away, his feet are pointing towards the structure, towards the residence. His head is pointing away from him. He's fully clothed, hood over his head. His hands, both hands or arms are under his body, and his legs are crossed.
Was Keith the first victim that was examined?
Yes.
Was he pronounced deceased?
He was pronounced deceased via telemetry by Dr. Toma from the Middlesex Regional Medical Examiner's Office. During the examination, I observed what appeared to be several gunshot wounds, particularly to his head, his back, and his torso area.
Those blue gloves in the picture, do you know what those are?
Those were by medical personnel upon arrival.
We could please have slide 132. What are we looking at here?
There is a bullet specimen. So we talked about the live cartridge, just a very, very basic. As a cartridge is fired from a handgun or from a firearm, the bullet is going to come out the barrel towards wherever the firearm is being pointed at, and the cartridge is going to be ejected out the side, relatively near the location where the shooter is. This bullet is located under his body, and obviously it's difficult to see, so we pointed to it with a gloved hand.
Can we please have slide 133? Closer.
Correct. That is a close-up photograph of that bullet specimen.
And 134, please.
That's just another close-up of the bullet specimen taken out into a gloved hand prior to packaging.
Was that bullet specimen, it was packaged and collected by you?
Yes, it was.
I'm going to show counsel and you what's been marked as S302.
All right, things like chain of custody, preservation of the scene, all very important in this case because the defense is challenging the way they went about their business, the police, that is. All right, we'll take a break. We'll have more testimony from the murder trial with Paul Carrollo next. Keep it here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. We'll get you back to testimony in the Mansion murders trial for Paul Carrolл in just a moment. But first, I want to remind you we are on verdict watch in the au pair affair double murder trial for Brendan Banfield going on in Virginia. The jury has been deliberating now for about 2 hours and 20 minutes or so. A lot to go over there, so it could take a little bit of time. Banfield is accused of conspiring with the family's au pair, Juliana Magalhaes, to kill his wife, Christine, and another man so that they could continue their affair. Magalhaes pleaded guilty to manslaughter and testified that Banfield was the mastermind behind the elaborate plot. Banfield also testified, saying he had nothing to do with his wife's murder, and if it happened, it was all Juliana Magalhaes. Well, now the jury will have to decide which story they believe. We'll keep a close eye on that courtroom, and when the jury comes back with either a question or a verdict, we will bring it to you live, of course. All right, I want to take you folks back to New Jersey now for more testimony of the Mansion murders trial for Paul Carroll. Prosecutors say that Paul Carroll killed his brother Keith, his brother's wife, and their 2 children. Then he set their mansion on fire to try to cover up his crime. The court is taking a break today, so we're taking this time to get you caught up on some key testimony. Let's pick it up now with testimony from that lead detective. His name is Stephen Vogt, still on direct by the Commonwealth.
302. Okay, what are we looking at here?
This is the envelope, which is labeled as 1-3, bullet specimen from grass under the body of Keith Canero, northwest of property, as well as my envelope, and this is from the State Police Lab, C18-10138, number 11, and this is the bullet on top.
If we could please have slide 135. What is this, Sergeant?
Inside Keith Canero's pocket was his wallet.
If we could have slide 136.
This is the outside of that same wallet. It's a plastic flip style wallet.
And slide 137.
The interior of the wallet and the general contents of it belonging to Keith Canero.
Was there was some cash inside the wallet?
Yes, there was.
Cards?
I could refer to the
Please.
property receipt. So the item, black flip side plastic wallet containing $210 cash, 4 credit cards belonging to Keith Canero, 1 Metro card, and 2 gift cards from left jacket pocket.
So Wallace, can I stop you for 1 second? When we flip on and off the lights, when we go from pictures to, let's leave everything dark except just this one light back and forth so everyone's eyes don't have to keep going back and forth to try to help you guys out a little bit. Can we just figure out which one that is so that we know it's not that one? It's not that one. Oh. So if we've just turned that one on, and let's turn off everything else real fast. I just want to see how it'll look. Just put that one back on. That's the one we'll put, no, just that one will go on, so then we don't have to continue to do that over and over again to the jurors and everybody else in the room. All right, thanks guys, I really appreciate it. You didn't realize that you were going to become a light specialist, did you, when you went to the... No, sir. All right, is that a part of the academy? All right, well, we're going to add it. I'm just kidding. All right, whenever you're ready, I apologize.
Okay, thank you, Judge. I'm going to show you what's been marked. I'm showing you on the S303. What is this?
This is that black wallet that I just referenced.
Okay, do you have gloves up here?
I do.
Can we please open that? Let me ask you, are there markings on there?
Yes, there are.
Okay, there's your number on there?
Yep, my number is 1-4.
And does that correspond with an item on that evidence property receipt?
Yes, it does. It corresponds with item number 4. You said open, right?
Yes, please.
You asked me to open it.
Are those the contents that were in there?
Yes, they are. We had inventoried it and then put it back, so that's why it's out of order from what it appears in the photograph.
Thank you. If we could please have slide 138. Sergeant, what is this that you're pointing to?
There's another bullet specimen that was recovered from that area near Keith Cannero's feet.
Can we please have slide 139?
A little difficult to focus, but in the grass is just a more close-up photograph than that bullet specimen.
Are you able to circle that on the screen?
Using that? Also, no.
If we can please have this preserved.
Sure, this will be 139.1, please.
That also packaged and labeled and preserved.
Yes, it was.
I'm showing counsel S304. I'm showing you what's been marked as S304. Do you recognize that?
That is item number 1-5, identified as bullet specimen from grass south of Keith Cannero's body near his feet on the northwest of the property. Evidence, or it's item number 12 for the New Jersey State Police, and then the item itself.
If we could please have slide 140. Sergeant, what is this that we're looking at?
So,
Could you just undo that for us? It's in the corner, the circle.
oh, I see.
Thank you. Sorry.
That's okay. This is a tamper-proof seal. So after the examination, Keith Cannero's body was placed into another more heavy-duty transport body bag and sealed with this seal. I photographed it to show that it had been basically the two zippers had been sealed together to show that the bag had not been tampered with or opened prior to transport to the medical examiner's office. They're also going to photo at the ME's office during the autopsy this same seal to show that nothing had been happened in between the process or during the transport.
Thank you. If we could please have slide 141.
So we then moved into, this is Jennifer Cannero's body located inside that bag. The time stamp that's written on top of that of 15:22 or 3:22 p.m. is the time when her body was removed from the scene and placed into that temporary pop-up.
All right, let me bring back in my guest. They're with us, trial attorney Gabriel Sepulveda Sanchez. And Gabriel, now this, of course, is a procedural part of the state's case, but it also provides some insight into the crime. You know, seeing those bodies in bags, seeing the little bodies of the child victims here under tarp on the scene, I think sort of hammers home the real horror of this crime, which is very, very powerful for them.
Yeah, definitely. I mean, those things, those pictures and photos definitely has an inflammatory. That's what us lawyers say, inflammatory impact. They're part of the case, but the DA, they want to show that to the jurors because they know that not only is it it's also, they probably don't need to show all those photos, but they want to because they want to get the juror angry. Angry jurors or they want to put someone down and ready to close this case, and they want to punish someone when they see those types of photos, especially when you hear about the young kids. But having the detective go on, it's not only just it's procedural, but he's also narrating he's kind of like the lead witness narrating the theory. They're going to talk about did you roll out other suspects when you did your investigation? Did you talk to the brother or alternative people? So it's not just a procedural thing. He's setting the tone for the case and kind of outlining and giving them the general outline, having the jurors be educated on what the full investigation showed and how grisly this crime was. Very impactful testimony, especially the photos, and it's very impactful.
Yeah, you know, the defense has a tough case here, Gabriel. There's no question about it. But there is an aspect of the case they're focusing on a little bit, and the idea is the nature of the crimes. What do you make of the nature of the crimes? This was a guy that apparently got caught stealing $80,000 from the business, or at least that's what they're claiming. He's charged with that as well in this case. But then he goes and kills the brother who found out the day after he calls him and tells him that he knows, and they're trying to cut him off. But then he kills the wife. Not only does he kill the wife and the husband with a gun, then he goes and stabs the children multiple times. And part of what the defense is saying is, look, he loved this family. There was no hatred with this family. Would he do this for $78,000 or something along that line? What do you make of the nature of the crime and what the charges are?
It's hard to believe that. Yeah, it's true. That that I would do the same thing as a defense lawyer. It's hard to believe this. Was he guilty of being a thief? And it's hard to believe that someone would go so far as to kill kids and the wife that have nothing to do with this. So I think that's a way of getting that in the jurors' heads. Like it's unbelievable, really. But we all know that people can do some pretty awful stuff. So that is a good point. Can this whole grisly, how awful this crime is? Is this really one person, or is there other people involved? Is it really the brother? Like it's just so unbelievable that jurors may question that, and that's a good position to take as a defense lawyer.
Yeah, and anybody in the criminal justice system, yourself, myself, our watchers at home know people do some unbelievable things. So it's really not that much of a leap. It's like, what could have gotten into someone to do some of the things we see here on Court TV? It just happens all the time. Nowadays,
you don't. Yeah, you don't know
Just don't know. Just don't know. All right. Gabe, stand by. We're going to take a break, folks. When we come back, we'll have more testimony from the murder trial for Paul Carroll going on in New Jersey. So keep it here on your front row seat to justice.
Tragic murder of Keith Canero and his entire family.
This one is the most brutal case that I've seen in my experience here.
The Mansion Murders Trial. Live coverage today on Court TV.
Tonight on closing arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest verdict watch updates.
Closing arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
right, folks, we're going to get you back to testimony in the Mansion murders trial for Paul Canero in just a moment. But first, again, we're on verdict watch in the au pair affair double murder trial for Brendan Banfield in Virginia. The jury has been deliberating now for 2 hours and 35 minutes. Banfield, of course, is accused of killing his wife and another man, Joseph Ryan, so he could continue an affair with the family's au pair, Juliana Magalhaes, a 21-year-old from Brazil. Magalhaes pleaded guilty to manslaughter and testified that Banfield posed as his wife on a fetish dating website to lure Ryan to their home to frame him for his wife's murder. Meanwhile, Banfield testified that Ryan killed Christine and that he killed Ryan in self-defense and did no such thing as catfishing. Well, we'll keep a close eye on that courtroom, of course. When that jury comes back with a verdict or a question, we will bring it to you live. All right. Now, as we were bringing you live testimony from Brendan Banfield in the au pair affair murder trial in Virginia, another major murder trial was still going on in New Jersey. That's the Mansion murders trial of Paul Canero. The prosecutors say that Canero shot and killed his brother Keith, killed his wife as well, and then stabbed their 2 young children to death before setting their home on fire to try to cover up the evidence. They say he did it because Keith had found out that Paul was stealing money from the family business. Court is dark there today, so we're getting you caught up on key testimony. Let's go back in for more. We're still listening to that lead detective, and he's going over items found at the crime scene.
4 p.m. was the time when Sophia was moved from the porch area and placed into the transport body bag. Sophia sustained multiple stab wounds throughout her body, to include her face, her torso, and her extremities.
Now, was Sophia Canero the only victim who was not photographed where they were found inside of the house?
Yes.
And is that because firefighters took her out pretty quickly?
Correct.
146, please.
That is that tamper-proof seal after the bag that Sophia Canero was placed into a more heavy-duty transport body bag, and the seal of 3947721 was secured onto the bag.
I'd like to talk about what you did after you went with the medical examiner's investigators to examine the bodies. If we could have slide 147. What are we looking at here?
So I'm starting, at this point, documentation or the search of the scene, particularly where Keith Canero's body was located, so northwest of the property or the northwest side of the property. At this point, we had a little more time, and we utilized placards or numeric evidence placards to document the locations of these items. So you can see, so the numbers that are used for these placards don't show a series of events or chronological order. We're just for documentation purposes. So we can see item number 4 next to the blood where Keith Canero's body was. Again, use this tree as reference, obviously the blood as well, but the tree is referenced throughout these photographs to show what we're looking at and orient the photographs.
148, please.
So now showing, taking a photograph, you can see evidence marker 4 and the blood staining to the left of this photograph. Far near that decking area on the top right of the photograph. It's hard to see in this photograph, but it's going to be evidence markers 1, 2, and 3.
And I know you've said it, but just to be clear, those were shell casings?
Yes. I don't think I did say it, but 1, 2, 3, and 4 were shell casings.
And 149, please.
So I'm starting to take my mid-range photographs of those items, so working my way up towards the deck, so just a little bit closer.
Were each of those shell casings, so 1, 2, 3, and 4, were they collected and preserved?
Yes, they were.
What were the head stamps on those?
They were the same as that live cartridge from the back deck, which again is GFL 10 9x19.
Can we have slide 150?
This is just a closer up mid-range photograph of evidence placards 1, 2, and 3.
And 151?
A close-up photograph of the discharge cartridge casing or shell casing, evidence placard 1.
And if we could have slide 152.
This This is more of a almost mid-range photograph of the discharge cartridge casing, evidence marker 2.
153, please.
That's a close-up of evidence marker 2, as well as that discharge cartridge casing.
154.
This is a mid-range photograph of evidence marker 3,
155.
and a close-up of the discharge cartridge casing of evidence marker 3.
Can you sort of see that right there in the grass? Is that where that is, the gold?
Yes. Circle.
I don't think we need to circle it, but you can see it. And S154, or slide 154.
Again.
Is that 3? I'm sorry, or 156, I apologize.
This is evidence marker.
All right, coming to the top of the hour, that means we have to take a break. I want to thank Gabriel Sepulveda Sanchez for joining me this hour. Folks, I want you to stick around because coming up, Court TV's Kelly Craft joins us live from Virginia for that verdict watch in the Brendan Banfield trial. So keep it here on your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala, and we are, of course, on verdict watch in the au pair affair murder trial for Brendan Banfield. The jury has been deliberating now for 2 hours and 45 minutes. The prosecutor said in closing arguments that Brendan plotted with the family's au pair to come up with an elaborate plan to kill his wife, Christine, and another man who kind of got caught in the crossfire here, Joseph Ryan. Banfield admitted on the stand that he shot Ryan, but says it was because he found Ryan stabbing his wife in their bedroom. Now, in the defense's closing argument, Banfield's attorney says the au pair, Juliana Magalhaes, is the one who came up with the plot. Well, it's now up to the jury to decide which version of the events they believe. Well, joining us now from outside that courtroom is Court TV legal correspondent Kelly Craft. All right, Kelly, great to see you as always. All right, what stood out to you from the defense's closing argument today?
Hi there, Michael. Well, I think defense counsel did give jurors a lot to think about. And we are coming up at the top of the hour, 4 o'clock, only a half hour left before our hard out today for the jury. One juror has to leave at 4:30 today. So we are coming up on that pretty soon. So it's hard to say if we're going to get a verdict yet in this case today, and we may have to come back on Monday. But talking about defense counsel's closing argument, he gave them thoughts on the investigation and how investigators had to be transferred out. He presented evidence and testimony in regard to that. Investigators transferred out because of their involvement and their theories regarding the Banfield case. Also, he told them that Juliana Magalhaes, the au pair who was having the affair with Brendan Banfield, he told them her testimony was bought and paid for and that she lied. Also, we're going to play a little snippet from his close in which he talks about the why. Why would Joseph Ryan stab Christine Banfield? This gave jurors something to think about. I noticed when he was saying this, a lot of jurors, it really piqued their interest as well as other people inside the courtroom. Let's go ahead and play that snippet.
Why? Why would Joe Ryan stab Christine? He had a gun trained on him, and he was telling him and was told that he was going to be arrested, and he was angry. Who was he angry at? Could he have been angry at Christine, thinking that she set him up? Could he have been angry at his situation for deciding to go into a house that he didn't know and put himself in this situation? Could he be angry at my client, who was there to try to figure out what was going on and ultimately try to protect his wife? Those are the whys.
Defense counsel said to jurors, go look at the evidence. Go back there, look at the exhibits. I'm asking you to do that. I would assume that's what they're doing as they've been out now for a few hours, Michael. So it looks like, as I mentioned, coming up close, half hour left here today before one of the jurors has to get going.
Yeah, he certainly did give them a lot to think about, for sure. Even those phone records, things of that nature to think about. And again, I think it kind of got off track when the defendant took the stand. But anyway, let's talk about the rebuttal close. The state took that opportunity to continue to pound on their theories. What stood out to you?
Michael, so during that rebuttal close, the prosecutor said, look, the digital forensics are not perfect in this case. No one can say for certain who was behind those devices. She says, according to the prosecution's theory, it was Juliana Magalhaes as well as Brendan Banfield. The defense has said that's not the case. And she said no one can tell you exactly who was behind those devices at that time. So she pointed that out, saying that part of her case is not perfect. But then she talked about something that Brendan Banfield said when he was on the stand. And Michael, you said it kind of came off the rails a bit maybe when Brendan Banfield took the stand. And this is one of the things that he talked about, having an important meeting that day that Christine Banfield was killed. Why don't we go ahead and listen to what the prosecutor had to say about what Brendan Banfield had to say about that meeting and that it's a lie, according to her.
He told you that he had a big career-defining work meeting the morning of the murder. And then you heard from his boss, who said, no, he didn't. He lied. He said that he and Juliana did not have a plan to kill Christine at the time that they went to the shooting range. Well, he said not at that time. If he's lying about the things that don't matter, how can you believe a single word he said?
I thought that was a good remark by the prosecutor during her rebuttal. Michael, a lot of people were talking about it afterwards that were just sitting inside the gallery. A lot of people liked that response because if he's going to lie about small things, now what about lying about the big things? Now, is it possible when Brendan Banfield was on the stand and talking about a promotion that he would be meeting with someone about maybe there are some people that didn't know about it? Again, anything is possible, but she's saying that whole idea was a lie.
Yeah, and again, that was his supervisor. So if he was in line for promotion, you think the supervisor would know. So again, I mean, she just did that consistently throughout his time on the stand, as well as in her closing argument. Kelly Craft, thank you so much for that. Truly appreciate it. Folks, I want you to stay here with us because I want to welcome in my guest for this hour. Joining us is defense attorney and former head prosecutor Bob Bianchi. Bob, great to see you as always. Thank you so much for joining me here. Now, after these closing arguments, I'm really looking forward to finding out how you feel. If either side moved the ball a bit, again, I said this earlier, I thought there was a lot to work with for the defense until the defendant took the stand. Then I think it sort of vitiated any movement they had made or any ball movement they had made in this case in terms of swinging any juror in their direction.
Yeah, I think we were talking about this last time we were on the show, Michael, and this decision to take the stand, which, of course, as an attorney, you can advise your client not to take the stand. And to, in most cases, you're saying the government has to prove its case beyond a reasonable doubt. And I go back to my first boss that trained me as a trial lawyer, as a prosecutor, who said to me, jurors love to convict from the mouth of the defendant. If there's a number one way, and if you can get that defendant to admit that they lied or show that they lied and they lose their credibility, it's brutal and devastating. And he did get caught in two areas, including the one that your reporter just mentioned, but also that this affair was a casual affair, and yet they're bringing out evidence that they were planning the names of their children and that it was far deeper than what the defendant is saying. So if that jury, I think that there was a lot to work with. The prosecutor's admission that there's not digital forensic evidence to support who's the one who did the catfishing. Brutal for the prosecution, but did he make up the difference in testifying and lying for the prosecution? This is a close one to me.
Yeah, I don't know if it's a close one. I thought it was close after that digital forensic testimony. Their expert, I thought, raised some real questions. And I think, and Kelly Craft even said it, some of the jurors were taking notes. They were really sort of clued in on his testimony because it's very sort of precise. I imagine they're going through some of those records now. And there were suggestions that he was kind of this mastermind who had made accounted for some of that stuff. But I thought at that point, right when he was done, there was maybe opportunity for one or two jurors to say, hey, wait a minute, I'm not ready to convict this guy.
Yeah, so I think you're saying that maybe him taking the stand actually was to his detriment. I think I'm getting that feeling, and that's how I felt after the state's case. I felt that there were holes, and this is the question that we'll never have answered. I have tried cases as a prosecutor where I'm like, why did the defendant take the stand? It was literally the worst move they could make, and I blew the defendant apart, and that's the reason why they got convicted. And in a lot of those cases, the lawyer advised against the defendant taking the stand, but the defendant, many of them, high-end, I hate to say it, this is how I see life, the realities of life, but smart, well-educated, type A, in control people feel that they can get over. They're used to being in control. And so they get on that stand a little more chesty than they should be and get beat up. I think that's what kind of happened here.
Yeah, I would have to agree. I would think that this is something his lawyer would have advised against. And this guy being exactly how you described, saying, nope, I want to get up and tell my story. I want to take a listen now to part of the state's closing where they talk about the possibility of the two of them working together in this case and what that might mean for the case. Let's take a listen.
If you think that Juliana Perez Magalhaes and Brendan Banfield were working together to kill Christine and Joseph Ryan, then Brendan can be responsible for Joseph Ryan's death, regardless of which bullet did the most damage. It's not a test of either or. They were working together. That makes him equally responsible. At the end of the day, I don't think that there can be any reasonable doubt that Mr. Banfield has committed each and every one of the offenses that we have put before you today.
Bob, do you think this idea that perhaps they did work together, which I think was sort of the overriding theme that came away from the evidence in this trial, will that affect the way jurors look at the case, and how?
Yeah, so she's making very clear to the jury, because there will be jury charges and instructions on the law that are read to the jurors, and the jurors are not allowed to opine what they think the law is, but what the judge tells them the state legislature says the law is. And what the prosecutor's doing there, and I've done this with felony murder and conspiracy cases, where I worry the jury's going to make a mistake about, if I can't prove exactly who's the person that shot or exactly which bullet is the one that killed them, that they understand the unifying theory in New Jersey, and I'm sure the same is true here, that if they're in a conspiracy and working together, each is responsible for the totality of the carnage that they commit. So I think that that's what the prosecutor was trying to say here. And to the last, kind of wrapping it up here, the prosecutor had to rely upon the co-defendant as a witness here, gave this sweetheart deal, and now has to make sure that she protects the queen, if you will, and shows that all of the evidence supports her version of the story. And to the point that you raised before, that may not have been necessarily what the jury came out with until he took the stand.
Yeah, I would have to agree. And again, let's not forget, she got a deal that said she was guilty of manslaughter and time served. So that, I don't know how that's going to lay in the minds of the jurors as well. As you called it, a sweetheart deal. All right, Bob, stand by. We're going to take a break here, folks. When we come back, we're going to have more testimony from the murder trial of Paul Canero going on in New Jersey. That lead detective still on the stand, so keep it here on Court TV.
An affair with the family's au pair lead to double murder.
I'm gonna kill her. I'm gonna kill her.
It's a case of sex, lies, and deadly deception.
The Au Pair Affair murder trial. Live coverage today on Court TV.
Tonight on closing arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest verdict watch updates.
Closing arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
We
right, folks, we're going to get you back to testimony in the Mansion murders trial for Paul Carrollo in just a moment. But first, the fate of defendant Brendan Banfield is now in the hands of the jury. Now, they have been deliberating for over 3 hours at this point. He's accused of being the mastermind behind an elaborate plot to lure an unsuspecting man to have violent sex with his wife. And then they wanted to frame him for her murder. We're going to bring you into that courtroom, of course, if there is a jury question or when there's a verdict. You're looking at the Great Seal of Virginia there in that courtroom. And again, we're coming up to that point where they're going to make a decision if the jury's going to go home or will they have a verdict today, because the juror does have to leave by 4:30. So, of course, when that happens, we'll let you know. All right, we'll turn now to New Jersey for the Mansion murders trial for Paul Carrollo. Court there is dark today and testimony set to resume on Monday. Carrollo faces life in prison if convicted of killing 4 members of his family back in November of 2018. Now, the body of his brother Keith was found on the front lawn of his home. Now, Keith's wife's body was found inside the house along with their 2 young children. Now, we're bringing you key testimony from key moments in the trial from earlier this week when, of course, we were covering that Brendan Banfield trial. Let's pick it up here with testimony from the lead detective. His name is Stephen Vogt.
This is evidence marker 4, and which is just to the east of the blood staining where Keith Carrollo's body was located, and that's more of a mid-range photograph.
157.
A close-up photograph of the discharge cartridge casing and evidence marker 4.
I'm going to show you what has been marked now as S305, 306, 307, and 308. I'm showing counsel. We could start with 306. If you could just tell me what they are and what they correspond to on your evidence property receipt.
Sure. What number are you starting with? I'm sorry. 305, right?
First one, 305.
So, Exhibit 305 is my item number 1-6, which is identified as EM1, so evidence marker 1, cartridge casing, GFL 10 9x19 from grass near paved deck on northwest of property. My packaging, as well as the packaging from the New Jersey State Police Ballistics Lab, again has that same item number or case number, and then item number 13, as well as the cartridge casing.
And the New Jersey State Police number on there?
Yes, it's 13.
Okay. S306?
306 is item number 1-7, EM2, cartridge casing GFL 10 9x19 from paved deck on northwest of property. New Jersey State Police number 14, and then the discharge cartridge casing on top.
S307?
My item number 1-8, EM3, cartridge casing GFL 10 9x19 from grass near paved deck on northwest of property. New Jersey State Police item number 15, and a discharge cartridge casing.
And finally, S308.
308 is my item number 1-9, EM4, cartridge casing, GFL 10 9x19 from grass near reddish stain near Keith Carrollo's body on northwest of property. Item number 16 and the discharge cartridge casing.
I'm going to show you next what's been marked, and I'll show counsel, is S332 and 333. And grab them. We'll start with S333. Do you recognize this package?
Yes, I am.
What is that?
This is my item number 1-30, a GE electrical meter recovered from the ground underneath the exterior electrical box northwest of property.
Are your numbers on there from your crime scene unit?
1-30.
Okay, and does that correspond to the evidence receipt?
Yes.
Okay, if you could please open that.
Well, the description does. It's in the evidence receipt. It's item number 7.
Can you just describe what that is?
So it's a GEKV2C multifunction meter, electrical meter. It's the extent of my explanation. I don't know much about it. Yes, it was found on the ground.
The next item, S132. I'm going to ask you if you recognize that by the markings first.
Yes, has my evidence tag 1-29, gray-colored exterior electrical door box from the grass near the northwest of property.
I'm not going to ask you to open it. Does that correspond to what is on your evidence receipt?
Yes, it does. It's going to be item number 6 on that receipt.
Can you open it? Because I just want to look at the
Sure.
Have the jury see the outside of it. Is that the door to the electrical meter?
Yes, it is.
Now, the meter itself and the door, did you do anything to process those?
Yes, we used fingerprint powder to dust it for fingerprints.
Any results come off of that? Thank you. If we could have slide 158, please. Sergeant, what is in this photo?
It's a photograph from the interior kitchen. It's a mid-range photograph locating the cellular phone that was on the counter there. So directly under, I'm almost standing in the location where Jesse Canero's body was recovered from, just underneath in front of those drawers there.
And we're going to look at some more pictures from the kitchen momentarily, but if I could have please slide S159. What are we looking at here in that photo? What were you trying to capture?
Almost directly in the middle of the photograph is a laptop computer, an Apple laptop computer, which was recovered as well.
And what did you do with those two items, the phone and the computer?
So they were ultimately turned over as well to Sergeant Broccolieri from the computer crimes unit.
Okay. Are those listed on the evidence receipt?
Yes, they are.
Okay. And does it indicate when you turn something over to somebody else?
Yes, it does. On the bottom, it says, so all of the items except for the cell phone were recovered by me and placed into the temporary evidence vault on the 20th. They remained there until November 26th when I turned over items number 8 and 9, which are the cell phone and the laptop computer to Sergeant Broccolieri.
I can take the evidence receipt. Did that essentially conclude the first day on the 20th of your processing of this scene?
Yes, it did.
I'm going to show you what's been marked as S286, 87, 88, and 85. Sort of ending. Let's start first. We'll go in order. I'm sorry. Let me just grab. We'll start with S. going to be S-288. Do you recognize that?
Yes.
Okay, and what is that?
288 is the evidence property receipt from the postmortem examination or the autopsy of Jesse Canero. It's going to be Middlesex Regional Medical Examiner's Office, case number 13-18-1300. They also reference that seal number that I took a photograph of, 131-81300.
No, when were all 4 of the victims' medical examinations or autopsies performed?
They were all performed on the 21st.
Okay.
November 21st of 2018.
I'm going to show you 286 and 287. Just tell me if you recognize those.
286 is the autopsy of Keith Canero, case number 13-18-1298. Again, documenting that seal number of 131-81298. And, I'm sorry, exhibit number 287 is the autopsy of Jennifer Canero, case number 13-18-1299. Seal number 131-81299.
Okay, thank you. I just want to take this from you really quick. I think there might be one that's
There we go.
You got a 4th one. Can you just tell us what the 4th one is?
289, or exhibit number 289, is the evidence property receipt for Sophia Canero autopsy. ME case number 13-18-1301, seal number 131-81301.
All right, there's that man we're looking at there, the defendant, Paul Canero, capable of these horrible, horrible crimes. That's what this jury has to decide. We'll take a break here, folks. We'll have more testimony in the murder trial for Paul Canero when we return. Keep it here on Court TV.